Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their court.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican for his service Latino. I didn't ask you to interrupt me. For Trump's sake.
Is that correct?
Whoa, it's really dark in here, guys. It's super dark in here. Well, that camera's not working. We'll get it fixed here real quick. Give it a moment. It'll wake up. It's been a rough morning. It's an eclipse. Eclipse in the studio. Good morning. Welcome to the Court of Public Opinion. I'm the Recovery Addict. Great to have you here this morning. It would be better if my camera was working. So let's everybody think positive thoughts about GoPro.
Might be upon us.
It's very dark outside. Let's think. Let's think some positive thoughts here. Let's see. Let's watch. Oh, not sponsored by GoPro. Wait for it. Boom! There we are. All right. Even before the song was over. That is awesome. We have made it all the way to this far in the show without a serious problem, which is just amazing. I didn't think we could make it that far. All right. Welcome. I have to say a huge welcome to Rianne K.
We're going to break for lunch, Judge.
Rianne, first in chat this morning, bright and early. I was growing the facial hair back. I am a little bit, not like intentionally, but just I have not shaved. I see that. First of all, Rianne, congratulations. You have won before. We've got you on the list of previous offenders, and you have won again this morning. That makes you a repeat offender. I think you were a repeat offender before, but now you're becoming a habitual offender, which is great. Congratulations. You have won the internet this morning. Everything IP-related worldwide is firmly now your responsibility to care for, to maintain, to fix. Everything you get, everything but the financial rewards of owning the internet. I don't know why those don't transfer with internet ownership. They just don't. Ask other people. I don't know. Nobody else gets to capitalize, financially on this engagement. But Rianne, thank you very much for being first in chat, because you made all this happen. You made everything that follows in chat is basically because of you, or because you opened the doors. So appreciate that. Thank you.
There's a
Jenny.
lawsuit.
Mike. What day is it, Mike? Guess what today is?
It's hump day.
Hump day! Welcome to Wednesday. That's all I've got. That was it. It could have been the fact that I had French fries for breakfast. They were leftover French fries. It's not like I went to McDonald's and got French fries for breakfast. That wouldn't be healthy. I had leftovers from breakfast, which is always healthy. Leftovers are good for you, right? All right. It was weak. Says Zoe. Weak. Wow, you okay? Melissa gives me that was fair. I guess I should... Your diet, says Virginia. About that. Let's do this. Let's close out the poll that's going right now, because we had a poll first. We said basically, are we going to get a verdict today? So this poll's been going for a little while this morning. Let's see if we've got a few votes on there. Looks like a couple hundred of you voted yes, 53%, no, 46. Yes, no, 46. I will tell you this. You ready? I was late starting today because Mrs. R.A. were talking about sometimes you plan in the future, like far in the future, and you're like, hey, we want to do this really cool thing. And then as it gets closer and closer, you're like, we just can't pull it off. We've done that many times. We're looking at running to D.C. tomorrow. like literally running up to DC for the day to meet some friends that will be there. Let's see. Oh, Steve, I am sorry. I kept an outdated version. I did. I will fix that momentarily. Obviously, that's not going to do much good for you guys now. Give me just 1 second. We're going to jump to trial in just a second because we have to watch a little bit of what we missed yesterday afternoon when I called it quits a tiny bit early. Let's see. Where is Bad Apple trial? Oh, man, it's looking good. This is looking really good. Got Sasquatch in there and everything. Okay, so we're going to download this guy, just page 1. As a PNG. We have to compress the file for YouTube. All right, I'm gonna fix this so the thumbnail matches. The river has changed. I think that's the most significant change. I'll show you everybody what that looks like in just a moment here. Let's see. Change to today. It's still trying to download. It's like a huge file. Did it download? Oh, just finished. Okay, I don't know. It was stuck for a minute. It was stuck in limbo land. And there it is. Okay, so we've now updated the thumbnail. So the new people who are looking for this will see the correct thumbnail. All right, somebody said I'm on a bus right now, and controllers, people who check the tickets, got on, and like 10 people exited. I guess they don't have the right tickets. Oh, man. Usually they lock the doors and like, all right, everybody, tickets or the fine. Let's see. We have Sharon. I see that. Thank you very much. We have. Before we go to birthdays. Let me show you the thumbnail where it's at right now, because the crew has been hard at work on this thumbnail. Come on, focus, eyes, focus. Oh, I shrunk it down. Had one job and I messed it up. Okay, here we go. Our thumbnail. Now I can make it bigger so I can see this.
This is not Burger King. People do not get to have it their way.
Our thumbnail right here is and it now looks more like the Apple River, but we've got floaty tubes, Sasquatch, 10 seconds. You've got 10 seconds. We've got a bat. We've got the eclipse. We've got the blood donation, cameras set up, tape measure. I don't know. What is this? What is this little... like a subliminal message down there. We've got the goggles floating in there. We've got all the different tubes, the splashes, the phones that are out, the beer coolers.
I'm not a cat.
The shoes that were lost. I guess the bad shoes. We've got like a little fight going on here between a seahorse and a cat. Pow, slap. Let's see, polar bears. I don't even know what half this stuff means. We'll have to, when we have more time, we'll do this. A bearded bee. We have a bearded bee, a scaredy cat over here. We've got football. I can't even see this stuff. Oh, a shark, baby shark happening over there. Because they were doing baby shark. I know that part. They were using baby shark to do the rhythm for CPR.
More experience.
We've got a shower. Bob Ross painting going on. Wow. I don't even know what to say. I don't even know what to say. This is incredible. There are so many things here. We're going to need probably a breakdown. There's a pocket knife right there in the bushes. A beer can. I'm looking for where vodka is represented. And it's probably on here somewhere. But anyway, this is great work. We're gonna get into that. We've got little bears in the cooler and a wand. What's the wand for? A dolphin. I'm lost at some of these things. I realize all of these things have meaning. This is like the Where's Waldo with a philosopher's twist. But Stephen got the new one on there. It's a Mary Jane shoe. It's a Mary Jane shoe. Okay. Mandy, thank you. He's buzzed, but he can still walk. Mr. Mew is a cat. Bears are for two beers. Polar bears is 2 cold beers. Yeah, I'm getting a lot of explanations. Okay, here's what we need to do though. I don't have time. I love the kitten slap. The changed background looks great. This river looks fantastic. It looks more like the actual river. So that is really good. Great work there. Let's see. Is anyone else going to watch Daybell today? If you're going to watch, I'd suggest watching with Brandy. Brandy's going to be watching that one today. No, I think polar bears are for White Claw. The polar bears are White Claws, apparently. Okay, good stuff. All right. That being said, let's get everything ready for where we should be right now on our trial, which skipped ahead on me. No. It was supposed to save the spot. Where did we end up? We missed jury instructions. Do we want to go back and watch the jury instructions? I thought we had just a few minutes left of jury instructions. Of jury instruction deliberation, that is. No on that? No. Lots of no's. Oh, we have to do birthdays. Sharon, you told me, and I forgot. Let's do birthdays before I forget again. Welcome. It looks like we have Melissa P. has a 29th wedding anniversary today. Melissa, happy anniversary to you and your husband. Appreciate that. Danny, Antonia, David, Carler, all celebrating their special day today. So Danny, Antonia, David, and Carler. Danny, Antonia, David, and Carler. We can sing to those 4. Will you guys join with me in celebrating the birthdays for Danny, Antonio, David, and Carler? Carler. I want to say Carla, and I just can't throw the R on the end. Carlar. We do this by singing. We sing the happy birthday song. It's a song everybody knows the words to, so you're required to sing along. Let's see. Jury instructions are today. Oh, forgot it's hump day. Josh, I did hump day. Josh, you're late. Hang on just one second. Let's birthday song. To all those who are celebrating, we're going to sing. I need you guys to warm up with me. Ready? La 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 la. Here we go. We're going to get all 4 in one verse. Here we go. Oh, stretch those jaws. Happy birthday to you. Happy birthday to you. Happy birthday, Danny, Antonio, David, and Carler. Happy birthday to you. All right, happy birthday and a huge 29th wedding anniversary to Melissa P. Happy anniversary. Wonderful to have you all here. Thank you for all the people who are celebrating their birthdays today. Thank you for being here. We realize there are a million places you could be and a million people could celebrate with you. But you've chosen to be here with us. Thank you very much. We appreciate that. We hope we can make your little special day a little better. So happy birthday to everybody. Get free pancakes at Denny's, hopefully by pre-registering and then showing up and showing your driver's license or something. I wish I could tell you all the requirements. I think there are more. But there are some free pancakes in there somewhere for you at Denny's if you followed all the fine print. So thank you. All right, welcome. Let's see. Dr. Bullbutter says, I'm here at 8:15 and I was late. I quit going back to sleep. Some of us warmed up and stretched early this morning while waiting. Oh, good, Paula Mac. I was not able to follow all the preparations this morning. I did see quite a few of you on and talking and getting ready for the day, which is good. You have to download the app and wait for pancakes, says Melissa P. Melissa did this. Probably the first person who I've told to go to Denny's to get free pancakes on her birthday. What, last week? Was it last week, Melissa? On her birthday last week, she went to Denny's. She's like, hey, Recovery Addict sent me. I'm here for the free pancakes. And they're like, you must be mistaken. Yeah, you need the app. You need the app, apparently. So as much as you advertise for Denny's, they owe you free pancakes even when it's not your birthday. Abby, I've been telling them this. I tell all the stores this, but so far nobody has bit on that one. Last Thursday it was. So Mary M says, I'm literally eating pancakes right now. So that is awesome. I'm so happy you went and figured that out, Melissa, because you were the guinea pig, really, and you sort of figured it out for the rest of everybody else. Okay, so we got a resounding no on the pre-watching the jury instructions, because we're going to hear all the jury instructions again today, the ones they decided on. And I think we already got all the spiciness of trial as far as the arguments out already. So this is, it's not going to be, it's not going to be, there isn't going to be a lot of spice there that we missed, I think. Okay, let's, okay, where's, I know. Hang on, I need to back up. Okay. Trying to get all our streams lined up. I don't know where it is. I'm not sure if they have the new stream for today yet. That's not it. Sorry, I'm trying to look around my camera. It's not working very well. Uploads. Past live streams. Where's future live streams? Is that not a thing? There it is. Right there. Boom. Oh, we've got some time. We have some time. Okay. All right. Let's see. If we have time, we can go get the other ones set up as well. Love that color shirt, Warrior Woman. Hey, Tammy chose the shirt for me. And not only did she choose the shirt for me, she made the shirt for me. I mean, look, it's got like over here. It's got a little RA logo. So a big shout out to Tammy for making this one. I love it. I really love this shirt. It works well. Let's see. Tori, the Seed Lady. I made it to full term. Woohoo! Love being here. 9 months. Congratulations. Gender reveal, Tori? What did we do there? 9 months. That's awesome. Congratulations. It wouldn't be the same without you, Tori. Thank you. Thank you so much. I don't know if she embroidered it. I think this is probably a transfer of some sort. It's not embroidered. Ellie Veldman, hello all. I forgot this thing again. It's 11 months and 29 days. Well, you're going to get another one in like a couple days, so don't forget that one. Let's see. Pancakes are better than waffles. That's why I go to Waffle House for free waffles. Josh, Waffle House gives free waffles? I mean, they're not very expensive to begin with, but free waffles is better than paying for waffles. Good morning, Cynthia Beck. Welcome. Good to have you here. I'm not awake yet, and that hump day didn't wake me up. I'll be back. This is Melissa. Sorry, it was a week hump day cheer. Maya counter. I can show you Maya counter. Talked to Dr. Joe the other day, trying to get his burner phone working. I just sent him a fix this morning, bright and early this morning. I sent him a fix to get the burner phone working. Hopefully that works out for him. 3 days to the Orange Courthouse, says Kimbers, Ohio. So close. That's going to be exciting. I didn't see any responses. More about Washington. Let me tell you, I think we're going to go to one of the museums in Washington, D.C. on a one-day trip, meaning no overnighter. No. So here's the thing. I need to know. I can probably Google this and find out, but since there are lots of you and one of me, and I'm like crunched for time, here's what I'm looking for. We'll say, like, I don't know, don't they have like an aerospace or a science, isn't there a space museum up there? There's a free space museum. I think that's the one we're headed towards. Do they allow you to live stream inside the space museum? Because if so, I can grab my live view and take you with me, and we can all go to the space museum. That would be really cool. When will we hit 4444? We gain 51,000 roughly, a little over $51,000 every day. So 2 days to 325 or 325, 4 days 3 4 1 2. It's 100. We need 200. That's 4 days. A little over 4. Right around 4 days. Abby, right around 4 days. So possibly on the weekend. So air and space. They're saying yes. I'm crowdsourcing information. I'd rather see 444 than the eclipse. You say that because you weren't here. I've heard some incredible accounts of people who saw the totality. Please stay weather aware. I've seen lots of tornado watchers in Louisiana and Alabama. Please stay safe, everyone. Please do. This we had crazy weather, and apparently all the nerds. I say nerds as a term of endearment. All the really smart people over at the place, the NOAA, the hurricane place. They think this year is going to be like the year. They have we're going to have 80 active storms or something. It was a huge number. It's like a record high. So yeah, it's going to be a weather year for sure. It's a good year to be Thomas. Let's put it that way. Don't park without paying someone to watch your car. Okay, Virginia Little, this was my question. If I go to the Smithsonian or the Science Museum or something like that, can I take my live view in? So camera, small backpack, things like that, or the Air and Space Museum, whichever one it is. I don't know. I don't know which ones they are. And will any equipment I leave in my car get stolen? I'd recommend the International Spy Museum. Very cool place. Yeah, but I think just going there puts you on the no-fly list. Shaky ground. Had a couple tornadoes this morning. Had a couple pancakes too. Mary, the way you say that is just nonchalant. Hopefully everyone's safe. Thank you. Ryan Hall-Y'all's live. If he's live, there is severe weather out and about. We had to reserve time for the Smithsonian Air and Space last November. Check before you go. You said backpack. I did. Bella. Now, well, they're cheaper after hurricane season because you have to do the repairs. Lock-in trunk. I've got a Yukon. I've got a Yukon XL. There's no trunk. It's all one big cab. I have no way to lock things other than just in the car. RA, don't tell me about that about hurricanes. That's not what I want to hear. I'm sorry, Hazelnut Pretzel. I heard it on the radio the other day, so it must be true. Take the Amtrak train, drops you off right in the middle of D.C. Super reasonable price. Angela, I hear that. What I'm asking, yes, camera gear will be stolen. Please be aware. It's just that bad. Okay, so if they allow me to take gear inside, and can you pay someone to watch your car? I mean, and how do you find someone to trust? Info on burner. Okay. The burner's still loading. Hang on. Okay. You have to sign up for free ticket online for the Air and Space Museum. I got that, but about the parking. First of all, I don't want anything stolen. So anything I bring with of value, I need to bring with me, right? I need to have. So if I bring my MacBook Air and my live view and a camera, I need to be able to carry it into the museum, and I'm not sure if security will let me carry all that stuff in the museum. Pay a homeless entrepreneur. Cachette, as much as I support the idea behind that, I'm not sure if in functionality I will get the results that I'm hoping for. Matt Bond, welcome. Welcome, Matt. Good to see you here. Check burner. I keep checking the burner, but it doesn't say anything. Is it like a voice message? And why am I not getting calls? Oh, just got a message. Just barely. The internet is very slow here. Rianne, can you fix that? Okay, we've got Air and Space Museum. Free timed entry passes are required for this museum. Passes are not required at the Udvar Hazy Center in Virginia. Okay, they're trying to send people somewhere else. Working members of the media must obtain permission from the museum's coordination office and must be escorted by a museum staff member while in the building. Commercial photography is not allowed for the purposes other than those approved by the museum for information contact. Working members. So basically, I have to say, hey, I'm here with my family. Can I film? Can I post it on my YouTube channel? I live by Oakland and San Francisco. Some people leave their window down so they won't get broken. Otherwise, they will get broken. Is it that bad? You have a spare in the hatch? If so, take it out and put your stuff where the spare goes. We've done that before. Obviously, kept the spare in the hatch. Call and ask if security will keep it. Let me see if I can figure this out. All right. Well, we're going to begin trial here in just a couple of minutes. I don't know why the burner phone, nothing is happening. Let's see, Google Voice, is that up somewhere? StreamYard. Hey, call's coming in. It's Amber. But Amber's different because Amber gets right past the screener. Hey Amber, how are you doing? Like I don't have to say no, yes, I do want to talk to her, or no, I don't want to talk to her. She's just, it calls, it connects.
You just don't get a choice.
Someday you have to tell me how you do this, but
I will never reveal my secrets.
okay, so the good news is your call, which I think you called the burner number. It shows you called the burner number. It came in on my phone and it rang, which means it's connected, right? But
as far as I know,
I think I gave you like automatic privileges to connect, to bypass to bypass the call screener. I think I set you up as a special number, like a VIP setting or something. It was an accident. I didn't know what I was doing at the time. If I could undo it, I would. Amber, you sound like you're feeling better this morning.
I feel okay. My headache isn't quite as intense, which is why I'm able to laugh, which is fantastic. Yeah. But staring at a computer screen all day, I think, is just making it worse. So by the time I get done with work, I'm ready to go back and lay down.
What you need,
which is precisely what I did yesterday.
What you need is a good pair of headphones that you can just pipe in all the court noise and static right into your eardrums.
Right.
That's what I do. That fixes it every day. I'm happy you're feeling better. I really do. Did you have any information on DC for me?
On DC? No, I was calling to make sure that your phone wasn't still routed to the computer instead.
If it is, I can connect it. I just need to know where they're coming in at. So, okay.
Well, where are they coming in at?
Well, this one came in on the phone, but like I said, you're not a good, because you're VIP. I think you might be getting through, because I've had people say, "Hey, I tried to call, and it went straight to voicemail." But it shows that it shouldn't. Well, it shouldn't. So I'm not on Do Not Disturb. But Amber, thank you. Phone's working. get feeling better. And
At least for me.
Yeah. Anybody call Amber, and then she can call me, and that's how it's going to work. Every time I call, it goes to voicemail, so I gave up. Says Red Pen. Okay, we'll figure it out. All right.
Well, Red Pen, try when I hang up because I think it'll go straight to voicemail if he's on the phone with somebody. So
somebody's calling.
I'm going to hang up now.
Okay. All right. We'll see you.
Perfect.
Right, bye.
Goodbye.
Call from Lego Bidet Adam. To accept, press 1. To send a voice.
Lego Bidet Adam. I'm not sure who I'm talking to right now. How are you doing?
I kind of forget what I am, to be honest with you. Anyway, I just called in to say testing.
It's working. Okay, so the phone is live. The burner phone is back the way it should be.
Perfect.
This is
testing.
good news.
And you can hear me, right?
I can hear you. Can you hear me now?
2.
Can you hear me now? Hello?
Yeah, I can hear you. I can hear you perfect.
Okay. It's working well.
All right, I'm going to go. Have a great day.
You too. We'll see you.
Okay, bye.
Bye. All right, so the phone is back and working. If Mrs. R.A. was going to go to D.C. by herself, and I thought that's a bad idea, mostly because I am nervous about don't let folks wash your windows in D.C. either. Man, you guys are, this isn't like going to a third world country, is it? Gob says, objection, RA, my courthouse has been held hostage in no man's land. Take it up with YouTube, Gob. I promise it's not something I did on my side. This reminds me of a podcast sound check, which is coming up tomorrow. Podcast tomorrow. Super excited for. I think we still have a guest on the line for that one, on the hook, I guess we could say. Homeschool Ground Zero says, sorry for messing up the burner phone, guys. I had no idea I threw such a wrench in the works. She had the phone yesterday going into Raleigh. And this morning, I just about slept through my alarm because the ringer was turned like down to silent. I'm like, now I know why she doesn't answer when she has my phone. She turns the ringer off. Probably because it makes noise. She doesn't like it. I see you. Thank you very much for your super chat. I appreciate that. Also, we had 5 gifted memberships from Ellie Veldman. Thank you, Ellie. A new member from TC. Not new member, but a new member again. Welcome to the gallery, TC. Good to have you here. We are moments away from trial starting, so we're going to be jumping to that in just a second. We have audio set up so that it'll scare us to death when it happens. Let's see. What else did I miss this morning? There was a little... Oh, look, Matt Bond. Hello, my spiffy legal mumbo-jumbo talkie recovery dude. How I have missed thee. Matt, it's good to have you here. Thank you very much. Ellie Veldman also says, hello, all. I forgot this thing again. It's 11 months and 29 days. Tori, the seed lady, made it full term. Then Ellie, as she's pre-celebrating her year mark, gives 5 memberships as well. So thank you for all the generous people this morning making chat so exciting and fun. All right. Since Homeschool Ground Zero is here, just for a minute, if we can do this, I know this will probably cause a firestorm, which I'm okay with because today is a good day for that. I'm going to put a little poll up. There we go. Just for everyone to go ahead and vote on. If there's a no, I'm pretty sure I know which one that comes from. Yep. So, you guys are enabling me to skip exercising. Well, now they're enabling me just to justify a quick trip down the road. Let's see, Homeschool Ground Zero. No, we're encouraging you to exercise your brain. That's it. Shaky Ground member for 6 months. I've been incarcerated in this chat for 6 months. So thankful to be part of this amazing and generous community. RA, you're the glue that holds us together. Shaky Ground, thanks for the kind words. Thank you so much. But honestly, this community is a community of amazing people, and you are one of them. It wouldn't be the same without you. Thank you so much. Let's see. Happy anniversary on that as well. Let's see, the poll results are definitely, this is probably one of the most lopsided polls we've ever had. Nosy Rosie's like, I'm with you. The two of us will stand in the negative category. I just asked a quick poll. The poll says, should Mrs. R.A. get a cell phone? The correct answer is yes. You can also choose no if you don't want to choose the correct answer. But I'm not going to try to influence the outcome of this poll in any way. We want it to be as organic as possible. She at least needs a paper. I don't see the poll. It says homeschool ground zero. Well, good. You're going to skew the results. Virginia Little says, Mrs. R.A. doesn't have a cell phone. How is that possible? I will tell you, she has found the joy, because there was a time when we were married that she did have a cell phone. And when you have a cell phone and you have a bunch of friends, which she does because people like her, she's a nice person, people call all the time. And it was just not good, because you could never have a spare moment. And so she said, phones are items of convenience. I'm going to answer them when it's convenient for me, and it's not convenient when I'm out and about doing things to answer the phone. Now, there have been moments of inconvenience where we really wish that we did have a phone available so we could communicate back and forth. But those don't come often enough for me to justify saying yes, you need to get the phone. So that's what voicemail is for. But here's the thinking. Either I get her a phone, or we get her an Apple AirTag and like a smartwatch that will connect to the internet so that I can just see where she's at. It's not that I don't trust her. It's just that if something goes wrong, I want to be able to get to her and figure out what's up, or maybe give her a map to route her to a different direction if she's lost driving somewhere, because we all get lost. I got a phone when I got in a wreck. I used a stranger's phone to tell Scott. It takes about that level for me. Yeah, that's all she needs. Like, everyone else has a phone, so I don't need one. That's her whole. Yeah. Sorry to throw you under the bus here, Mrs. R.A. By the way, Mrs. R.A., don't chip your wife. Why don't you microchip her? The idea came in very quickly. Two different opinions on that one. Now do a poll. Should Recovery Addict listen to his friendly mods on how to set up the ability to take calls on Discord? Mathis, just in chat. You don't have to call. In chat, do I have to own the Discord? Do I have to set it up myself? Or should I here's what I can't do. I can't expect our good friends over at As the Gavel Drops to host my phone everything. That would not be polite or right of me to do. That's not what they're all about. Hey, Amber.
I felt a disturbance in the force.
You felt a disturbance. What's up?
I happened to go be refilling my coffee cup and came back to noise of the likes of Discord and setting things up for phone calls. No, you don't. Afraid, don't miss the forest for the trees. No, you do not need to own the Discord, and I've tried to tell you, we are more than happy to set up that channel, and actually you can go into the sidebar chat now if you wanted to. But there's nothing that we have to do special for you other than give you that platform, but we don't know that we need to make you that platform if you're not going to use it. So we can make it happen. I just need to know if that's something you want to do.
So how would it work for other people to connect? Would they call a number, or would they connect to Discord?
No, they would just connect to Discord. But you said the other day that when you run Discord, it slows all of your machines down.
Just the one that's running Discord.
I don't know. Just the one that's running Discord? Yeah. Is that an important one?
It's the one right in front of me. I don't want to put Discord on all my devices, because the updates and things, the notifications, I need to be able to limit notifications to one machine. Yeah.
You know what?
What?
You can actually have Discord on your phone.
I have it on
and
my
do
phone.
the calls through. Right, and you can do the calls through your phone. It would be just like a regular phone call, only through Discord. They wouldn't be calling a number.
The problem
so
is...
just like Facebook, Facebook Messenger.
I'd actually have 3 different ways for my phone to start ringing, so that if I get a normal call, it interrupts. If I get a burner phone call, it interrupts. Or if, Discord call, there's just lots of interruptions and beeps that way, and I'm trying to avoid that as much as possible.
Well, that's a whole different problem entirely. I was giving you the solution of, yes, that will work. We can make that happen. It is entirely possible.
Okay, I'm on as the gavel drops.
Mm-hmm.
Sidebar voice?
Sure. If you go into sidebar voice, anybody that's in the Discord can go into sidebar voice. That's where you have done like group chats before.
Okay. We're testing the audio. Hang on one second. The problem is in that one, it's just everyone talking at once.
Right. But, when you, here, let me go. I'm opening up my Discord on my tablet. Hang on. Are you in sidebar? You are in sidebar. So if I click on sidebar and click on you, I'm actually calling you right now.
I'm going to join the call. Hello?
Hello.
Wow. This sounds crazy. Let me turn it up. Okay, I'm going to hang you up on your phone. Okay? Can you hear me now? So this is a bad example of it working.
Hang on, I'm trying to get it to speaker. Hang on.
Okay, I can hear you now. But you're not hearing me through my microphone. You're just hearing me through my laptop, right?
Hang on, I'm switching over to my phone. Hang on.
Okay, Mathis, we fixed it. This will work. All right. Okay.
Okay, can you hear me?
I can hear you. Yes. Can you hear me? Now she's going to call me on the other phone because she can't hear me. Let's see. Can you hear me? Hello, hello. Hello, can you hear me now? Test 1, 2.
Can you hear me? Hello?
Hello. I think I've got like
I can hear you, but not through Discord. I have to listen to the live stream.
It's a built-in microphone. Yeah, because here's the problem. If I run my audio through the Discord, it causes loops because of how I'm routing audio. And so I would have to have like a separate headset just for Discord to talk so you could hear on that. So it needs some work still. We'll try to figure this out. Amber?
Discord isn't as bad as it seems, everybody. It's really not, I promise.
I think... Oh, wait. Can you hear me now, Amber, over Discord? Because I have push to talk set up, but I don't know.
No.
I don't know what the key button is. Hang on. What's it bounds to? The up button. Okay. Testing. Can you hear me now? Check 1, 2.
I can hear something now.
All right. Well, Amber, let's leave this testing for another day.
Yeah, I heard you're testing.
Over YouTube or through Discord?
That's fine.
Yeah. Okay. Thanks for calling me on both phones, Amber. I appreciate
Through
it.
Discord.
We'll catch you later. The delay is terrible. All right. I'll see you. Bye-bye. I just hung up on her. It didn't work very well. The delay was terrible. Dumpster fire, says Weather Watch. Nailed it, says Greeners. So can I call via WhatsApp? TC, the problem is my WhatsApp is linked to my actual personal number, which I don't give out. And I think if I can't link it to a different number, and so I would basically have to give you my personal number, which, I do have a little bit of privacy, at times where my phone is
from Angela.
Angela, I'm working on this. How are you doing?
I am doing good. How are you?
I am doing well. We're about ready to start trial, but what's happening?
Yes. I was catching up on 2 times speed. So slow they talked yesterday that 2 times were good, but I caught something and that's the reason why I am calling you today. You said something about weird reasoning when he stopped them and he said, "Oh, if I was deep,
yes, if I was a predator, then why would you be drinking alcohol or something like that?"
Yeah.
What? That didn't make sense to me.
You clearly have.
And good morning, and thank you.
You clearly do not have friends that are from Balkan. If I did not know that he is from Romania, that sentence alone, I would be like, he is from Balkan.
What does it mean?
Because that, it's. Let me just go back for a second. There is girl logic, boy logic, logic, and there is Balkan logic.
Is this this isn't like a joke type thing, right? It's not.
No, it's like people being how to say this, having protect. I don't know if the right word is protective, but since they are under 18 and since there is no grown up alone and they are doing something kind of illegal, and because of that their mind is not completely clear, and if someone really comes up to them that is a bad guy, then they would not be able to act rational.
Oh, so he's saying so. You're putting yourself in a bad position if that's what I am?
Yeah. That kind of means that.
Wow.
My parents are, I have spent half my life in Serbia. Mm-hmm. And my mom, thank God she's not listening to this. My mom has still that logic. And
How do you know? Mom, are you out there? Angela's mom, are you?
I know she is not. I know she is not listening, so I am safe for now, at least. But it's this weird logic, and I know that sometimes I had to tell my mom, seriously, people will not understand what you exactly mean because it will be taken out of context,
So it sounds like his comment then was sort of taken in if I was, then this is a better position for me to get what I want, right?
Yeah.
That's a little sick and twisted a little bit. That's strange.
Yeah, and that's where it went downhill. I am really wondering how long he lived in U.S., because he was married for 13 years or something like that. So I would say 15 at least. He
sort of avoided the question when he was asked about how long when he came to the country. He said it was his first language, but it doesn't mean that could have been his first language in the United States. Okay, he could have been just raised at home speaking that and been here all along. I think he came pretty early when he was pretty young.
Okay, I need to check with my friend who is from Romania also to verify this. But Serbia had mandatory military that you have to go to military when you turn 18. I guess and that happened. I think that stopped mid 2005 or something around that time. But I think it was the same in, I don't know if it's still mandatory in Romania to go to military. I have to recheck that.
I think it is, but I'm not sure if he was old enough to do that before he left.
I mean, if he was in military, then he was at least 18, because you can't join military before 18 unless you go to military high school. I don't know if they have that in Romania. They have that in Serbia at least. Yeah. So yeah, but yeah, that's, I want, like, it's a Balkan mentality. Seriously, you even can look up on Instagram and social media, like, things that only make sense in Balkan houses, or things that only make sense in, like, with Balkan parents. You know, you will have. I even saw. I don't know if lawyer you know, but since his dad is from Greece, but I mean, I saw people like, oh, things that just make sense in my Greek parents' house, and they're like, I find the same thing in my house. You know.
So some of those cultural differences are showing up in the trial. Then that makes sense. I appreciate you explaining that for us. I really do. That's that's interesting.
But he's like what, 56. So I don't know when he was in military, but I hope if it's not in 90s, because it's really bad on Balkan in 90s.
It's saying everyone's saying he wasn't in the military. He left at 15 or 16.
Okay,
so he came.
But his friend said that he was in military. So
I think his friend was wrong. His friend, because on cross-examination, they said, you don't know if he served or not. And he said, no. I think he just assumed. Yeah. But Angela, thank you very much. We've got a couple minutes before trial actually starts this morning. Thank you so much. We'll catch you again.
Welcome.
We'll see you. Bye-bye.
See you. Bye-bye.
Appreciate that little explanation there. I realize feeds are up. They're showing stuff from previous days. So we're just waiting for the actual live feed to begin, which it has not done yet. Let's see. He was 15. They fled the communist regime. I rescue dogs. The kids recorded a lot. I mean, a lot was caught, but I mean, this is one of the reasons why I tell you, don't record anything in portrait mode. Turn your phone into landscape mode. That's horizontal. The way it was intended. If we were supposed to view things in portrait mode, we would have our eyes. The creator would have made our eyes one on top of the other. But that's not the way we view things. They're side by side, view in landscape mode instead of portrait mode. There was so much that happened just off screen that if it just happened on screen, it would have explained a little bit more what was going on. And this case is just a poster child for that. Lisa Fintelman, welcome to the gallery, Lisa. Thank you very much. Brand new member this morning. Welcome. Please take a seat by typing !seat, Lisa. Good to have you. Just know you can never leave. You're here for good now. Kids were recording that to put on TikTok later. Ween Baby, I tell you, I've talked this over with Mrs. R.A. I was talking this over with Mrs. R.A. last night when Peter was on, and I pulled up his live feed for a little while and watched Lawyer You Know for a bit.
Just sent me a video of roaches fighting.
And I think I've come to a conclusion on this. I think, let me explain where I'm at, okay? And it's not a huge change from where I was yesterday, but I definitely feel that the events that happened on that day have to be divided up into different portions. You can't look at the entire day and say this was, based on the entire day, this person was wrong or this person was right. As I've said before, there's no heroes in the case as far as in the altercation. There were heroes afterwards in trying to help people, but in the case itself, everyone sort of has moments of blame. And the first altercation with the name calling, with what the boys basically started, they instigated. He had every right to be there in the river, as did they. Nobody has a right to say, "Hey, you leave this section of river; it's mine." It's not. Okay. Now you have personal space where you can be like, hey, that's too close. That's, you've got to get back. And that's reasonable. But when they came up to him, calling him names and everything, and he sort of ran at them, at the moment he charged at them, Had they been afraid for their lives, the boys would have been justified in using the applicable or the appropriate amount of force, whatever that may be. I doubt they could say deadly force is that one, but the appropriate amount of force to defend themselves against him. But he didn't attack them. Okay, he drops his goggles, he goes, and he starts walking away. Once he starts walking away, there has to be a dividing line, because he has tried to leave, and they approach him and start calling names again. I think at that point, we have to view it that at a different time. So the first time, I would say Nick was in the wrong, but he left. Now we have to look at it again and say, and then what happened? Once it happened the second time, when they pursued him, they were in the wrong and Nick was in the right. And, listening to his testimony, he said all the right words, and coached or not, he was afraid. He was afraid. He was nervous. He was trying to figure out what was going on. There was some level of confusion. The fact that he wasn't even speaking, goes counts to that. And these kids, tragically, pushed too far. I don't know about the last stabbing, the very last stabbing that occurred. I don't remember on the video if he went towards him, or if the boy went towards Nick, or if Nick went towards the boy. If Mr. Mew went towards the boy, then that one might be different. Okay, so I'm still up in the air on that one. But the rest of them, unfortunately, play stupid games, win stupid prizes, and I think that has to count here. It's tragic. It's tragic because it was. I don't think any of the boys would have done that had they thought through and said, yes, this is what's going to happen. And if any of them knew what was going to happen, I don't think any of them would have done what they did. I think they have regret there. But that being said, from that point on, Mr. Mew made some terrible decisions, which, if he were charged for them, he would be found guilty. But he is not charged with lying to the police. He's not charged with failing to render aid. I'm not even sure if that's a law in Wisconsin. He's not charged with those things. And although they're wrong, lying to the police and everything, those are wrong. But it's not a charge, and it's not an element of the other charge. So I really think that that tragically these youth basically put themselves in a situation where they were at fault and don't have defense. I think self-defense is what it was here. You can use lying to the police as consciousness of guilt. You can, but man, I would feel bad if I stabbed somebody, even in self-defense.
Mr. Mew is present. We are outside the presence of the jury. The jury was summoned in at 8:30, so they are probably assembling as we speak, but this gives us some extra time to wrap up some of our work. I do have a few things I want to address before we get back into the jury instructions. I meant to make a record yesterday about the sidebar. During Mr. Mew's direct examination, Mr. Nelson asked questions about nightmares. There was a state objection. We had a sidebar. It was my judgment that since Mr. Mew's credibility was being attacked, Mr. Mew's life experiences dealing with the traumatic events on July 30 were relevant. So I limited the scope of the inquiry to the fact that Mr. Mew was having nightmares, that they were about July 30, 2022, and that he sought out treatment or counseling for them. I did not allow the defense to get into what the medical treatment was, including prescription medication that he may have been given. I also instructed the state that given the objection and given my ruling, that the state would not be permitted to make arguments that Mr. Mew's experiences should be discounted because there's no evidence of a medical provider, a psychiatrist, psychologist, or prescription medication because they had objected to that evidence. So that's my summary. If anybody wants to add to it, you may do so.
That's my recollection, Judge. Yes, Judge, just to make it clear, I wanted to, as an offer of proof, I wanted to ask Nikolai about how his body responded to those nightmares. That is, when he woke up, what was his body feeling? Was he in chills? Did he have sweat? Was he shaking? If I had asked those questions, I would anticipate that he would have told me all of those things would have existed. I again think that that would further support his claim that the nightmares were real. Secondly, I wanted to ask him about the treatment, and I expected him to testify that yes, he saw a doctor and a nurse, mostly a nurse in the jail, and that he received a prescription for Prazosin, which it's his understanding and confirmed by my research that that is a prescription for PTSD-related nightmares. And so, again, as Your Honor somewhat articulated, it's our position that if the state attacks his credibility on that, I should be able to get that into evidence. It's our position that since they're attacking his credibility in general, anytime I can have his credibility supported on relevant matters, I should be allowed to do so. Your Honor gave the ruling that Your Honor articulated.
All right, and the attorneys do have the ability to rehabilitate the credibility of their witnesses. I just put limits on the extent that we were going to go into it. That's largely how I arrived at my ruling. I'll also note, too, that we've had a number of other sidebars where we didn't make records. Everybody has the opportunity to make a record if they feel one is necessary. It's been my recollection that most of these substantive rulings have had records made in close proximity to the time of the sidebars. Others, I may have made rulings on form questions, foundation questions, given the attorney's direction to move in a different direction or approach a problem from a certain perspective. I don't think they were substantive in nature. It was more technical. I think some of the other sidebars had to do with the attorneys putting me on notice about things that are likely to occur or may happen. But I don't remember any other sidebars that involved the inclusion or exclusion of meaningful substantive evidence over the objection of one of the parties. Anybody remembers something that they want to make a record of, you have an open invitation to do so. I also want to circle back to exhibit number 24. Yesterday there was a request to seal a trial exhibit. Neither of the attorneys have provided me with any law authorizing it, and unless you do so now, I conclude that you still do not have supporting authority. As a judge, I
believe yesterday I articulated, I think, exhibit number 24. I would just note chapter 950. I appreciate it's probably not my space to make that argument, but I will nevertheless. And chapter 950 involves the dignity of human beings, in particular victims, and in my opinion, the photos I think we're talking about the photos,
yes.
Right? Those photos being made public is contrary to respecting the dignity of those people that have that right.
I understand the thought and the sentiment. In a way, as a human being, I agree. However, as a judge, I have to follow the law when it comes to sealing records. And judges are very restricted, at least in Wisconsin, about what records can be sealed from the public. And the authority is defined specifically by statute. Things like juvenile records, trade secrets, social security numbers, pre-sentence investigation reports, psychological studies. Things like that are all defined in statute that a judge either is permitted to or is required to seal. Judges do not have broad authority to seal records that the judge thinks would be appropriate or to protect the interests of individuals, unfortunately. So because this is a trial exhibit, it's been received into evidence, because this is a public trial that does not involve a enumerated statutory basis for sealing, I don't have the authority to do so, even though I may prefer to do so. I simply just don't have the authority. So the request for sealing is denied on Exhibit 24.
Means people
provided the attorneys with a printed version of all of the proposed
Exhibit
verdict
24.
forms. Did anybody have any objections? No.
I don't.
Okay. So those will stand and be submitted to the jury. Is there anything else you want to address before we get back to the jury instructions? Okay, hearing none.
Actually, can we approach quick, Judge?
Yes.
Okay, so they're not done setting up the jury instructions. Not sure why they have to, with the jury gone, why they have to kick us out. But so I think there were medical examiner images or treatment images at the hospital, one of the two. I'm not sure exactly what was contained in item 24. But it's going to be photographs of individual and possibly some revealing photographs because medically it might be documenting things that that normally would not be visible under normal clothing. Let's see. We have a couple things I need to bring up here. We had let's see, Megan Easton. Yay! What a blessing this community is, Megan. I hear you're celebrating an anniversary yourself. Congratulations! Thank you very much. 11 months. My apologies to the dancers I overslept. However, I know that it's amazing. Great job, dancers. Nosy Rosie, thank you. Thank you. Regina Crawford gifted one membership as well. And we had Lisa Fintelman, brand new member, join us here as a member on chat. So please make room for her on the front row. Appreciate that. Reserved seating for members. Who won the interwebs today? Rianne K is our winner. Rianne K was the winner, Courtney. So if you have any troubles with your VPN at work, she's the person to contact. Interesting camouflage. I've never seen interesting outfit for court.
All right, let's table the sidebar for a moment. I want to get these jury instructions done so I can have them printed. We left off at 1072, the attempted crimes for counts 2 through 5. Mr. Nelson, you had a lot of objections yesterday that applied to 1017. Those same objections would apply to 1072 because the same issues exist in both instructions. So I've noted all of them for purposes of preserving the record. Are there other matters that you want to address in 1072?
Yes, Judge.
Thank you, Mandy.
In 1017 as well as in 1072 regarding the matter of second-degree reckless homicide on page 10 when you're talking about the homicide, and on page 20 when you're talking about the recklessly endangering safety, both in the second-degree matter. Both of them merely say the difference between first and second is the additional element. There is no mention in that discussion of second-degree reckless homicide, nor mention in the second-degree reckless endangering safety that it is the state's burden to prove beyond a reasonable doubt. I appreciate that it is in first-degree reckless homicide and it is in first-degree recklessly endangering safety. However, I think not including it in second to make sure and clear that the burden is on the state is in direct contradiction to the State v. Austin 349 Wisconsin Second 744 case that we've been discussing. This mistake, error in the instructions that were included is, I think, exactly what Austin says on page, or on paragraph 7, mentioning the jury instructions in Austin, it said, however, there was no mention of the burden of proof relative to self-defense. And it talks about that in the context of recklessly endangering safety.
The reason why this audio is so bad is they have their microphone pointed right at the ceiling, so it's picking up just room noise. They have to turn the volume up to hear him.
This standard instruction implies that the defendant must satisfy the jury that he is acting in self-defense. In doing so, the instruction removes the burden of proof from the state to show that the defendant was engaging in criminally reckless conduct. So I'd ask that on page 10 and on page 20, when discussing the second-degree reckless homicide and the second-degree recklessly endangering, that Your Honor add the words that I believe were added in other aspects, and that Mr. Mew was not acting lawfully in self-defense.
All right, the objection's noted. I am declining the request for the modification. And this comes from the pattern standard language from the jury instruction book, authored by the jury instruction committee. It's a committee of multiple judges who have studied these issues and have vetted appropriate language. The self-defense language appears in connection with first-degree reckless homicide and first-degree recklessly endangering safety. The jury will be instructed that one is not engaging in criminal reckless conduct if they're acting in self-defense. When we get to the second-degree versions of those offenses, the instruction makes explicit reference back to the wording from the first-degree offense, but simply tells the jury that the absence of utter disregard for human life, but the instruction for the second-degree offenses instructs the jury that they do not have to find the utter disregard for human life. So it's incorporating by reference the first-degree language. I think it is adequate. I think it is accurate. The attorneys will have ample opportunity to argue their respective points, including the importance of the self-defense being disproved by the state beyond a reasonable doubt. What's next?
That was the only additional request after reviewing the instructions, Judge.
Okay. And then last night we went through all of the other instructions. I'll give again another open call to additional instructions that you think, additional removal of instructions. Is there any changes, objections, concerns that you have to the jury instructions as presented?
Judge, regarding the excuse portion, I agree you can take that out. I'm not going to argue that in any way of provocation. So it was one of the bracketed instructions. It's on page 3.
Yes.
Brackets have to go.
It's a single sentence paragraph.
It is removed. Anything else from the state?
Not on jury instructions.
Mr. Nelson?
No, Judge.
Okay. So I'll have the instructions finalized. My intent is to read before you argue. I'll also have the instructions displayed on the monitors so the jury can follow along. The jury will be provided with a few copies of the printed instructions in the deliberation room for their reference. Mr. Anderson, at sidebar, you said you had a motion to make?
Yes, Judge, I have a motion to strike one of the jurors. It was brought to my attention yesterday that during portions of testimony yesterday, one of the jurors was sleeping for an extended period of time and to the point of nodding off and then jerking awake.
I'm sorry, sir, that was me.
Both sides have a right to a fair trial, which includes juries that are attentive. I'm looking at Wisconsin Supreme Court case, State v. Novi, 346 Wisconsin 2nd, 289. If there's a conviction, the defense could also try to argue that it violated defendant's right to fair trial. So obviously we want jurors who are paying attention to the evidence. So it's a two-step inquiry. One, it's a fact determination whether the juror was actually inattentive to the point of potentially undermining the fairness of the trial. And two, whether there's, this is the appellate review standard, if there's prejudice as a result.
Which juror?
4021.
Juror 4021. There is a 90-year-old juror on there. Let's hear a response from the...
Judge, we don't agree. I'm not looking at them, so I don't agree with the factual basis.
Mr. Anderson, if you want to pursue the matter further, you'll have to provide a witness.
State calls Investigator Schultz.
Investigator, please stand, raise your right hand and be sworn.
Do you swear that the testimony you're about to give in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do. Please have a seat in the witness chair. Mr. Anderson.
You've already testified, but can you please state your first and last name?
John Schultz.
And were you present throughout testimony yesterday?
Yes, sir.
At portions of the trial, were you watching the jury?
I was.
Was there a specific point during trial period of time, I should say, where you noticed a concern about whether a juror was paying attention?
Yes.
What did you notice?
I observed one of the jurors with her head down and would startle up with her head on numerous occasions.
What kind of time period, if you can recall? Was it like 10-minute time period, half hour, longer?
About an hour.
And she was dozing off and appearing to startle awake?
Yes.
Multiple times?
Yes.
And from reviewing our jury list in our office, we believe that to be juror 4021.
Correct.
Nothing else, Judge.
Mr. Nelson.
What time did this occur?
Perfect timing.
I can tell you during what portion of the trial, sir, but I don't recall the time. I apologize.
Just yesterday this happened and you don't know what time it was when it happened?
Correct. I can tell you the portion of the trial.
Let's start from there. During which witness?
Lieutenant Hart.
And during Lieutenant Hart's direct exam or cross-exam?
It would have been during her direct exam.
And that was the before the video or after the video?
During the video.
So was it during the exam or during the playing of the video?
I apologize. I think I'm getting confused. It was during the playing of the video.
Was it at any time other than during the playing of the video?
Not that I observed.
When you made these observations, you were sitting next to attorneys representing the state?
Yes.
Did you make note to them, pass a note, give an elbow, whisper in an ear?
No, I told them after or during a break.
So you made this observation while it was happening and you just, for lack of a better term, sat there and let it happen?
Yes.
Didn't bring it to the attorney's attention?
I did during the break.
How long was the
when
video?
You say the break after the playing of the video?
I believe so, yes.
Was there a discussion about whether the state thought the juror was on the state side or the defense side?
No, sir.
What was that discussion? Who did you tell?
During the break, I just told the attorneys that I observed a juror who I believed was sleeping. But I noted that I believe she was sleeping and not just closing her eyes because of her head quickly coming up like he would when you startle from waking.
And did you, at the time you didn't, your estimate of the time is, fair to say, rough?
Yes, sir.
You, during the actual live testimony from Brandy Hart, you didn't make an observation of any of this, correct?
Yes, sir.
It was correct. It was only during the playing of the video.
Correct.
And it was only during a portion of the playing of the video.
Correct.
The video wasn't an hour long. I don't think it was an hour long.
And your observation
was it an hour?
Was just as you said. She had her chin tilted forward towards her chest at a couple of times during the playing of the video.
Yes, sir. Her chin tilted, eyes closed, and then head would come up quickly.
And when her chin was down and her eyes would close, would that last for a moment, or would that last for 10 minutes, or you don't know?
I was out watching her over 10 minutes, so I would say a moment.
Okay. So her chin would go down for a brief moment, and then she would bring her head right back up. That's what you observed.
Yes, sir.
You didn't look over and see her chin down with her eyes closed, and then look over and see her chin down with her eyes closed, and then look over and see her chin down with her eyes closed. Agreed?
Sorry, I think I'm getting confused. Yes, that is what I would see.
Well, I'm trying to figure out this, whether or not you observed her chin down, eyes closed, and she stayed in that position for some continued period of time, or whether you observed her chin go down, there was a startled moment, her chin would come up, or whether you saw something else.
I understand what you're saying now. So I was intermittently looking over, and during that period of time, there was times where I would just see her chin down, eyes closed. I would look back, and it would be that way, and then I would see her startle with her head up.
So you're not in a position to tell the court the length of time that you observed her to have her chin down with her eyes closed? Meaning
continuous? No, sir.
All right, you don't know whether that was for 5 seconds, 10 seconds, 10 minutes. You can't say.
Correct.
You just essentially noticed it a couple of times.
Correct.
And by a couple, 2 to 3, is that fair?
I'd say 4 to 5.
Okay. And of those 4 to 5 times, half of them were you saw her with her chin down and she didn't make a response, and half of them were when she had her chin, you saw her make this, what you've called a startled reaction up.
Yes, sir.
Would that be a fair estimate?
That would be fair, yes.
And the times that you saw her with her chin down and eyes closed, it was again just a brief glance. You weren't dialed in, focusing on her. Agreed?
Yes.
You agree with that?
I do agree.
This is cross.
Nothing else.
Jameson?
So the
Redirect.
4 or 5 times, is that when you saw the head jerk?
It was both. At times I would look over and she just chin down, eyes closed, and then I would look over again and I would see that and then see the head jerk.
And did you see that for what period of time approximately from when you first noticed that till the end? Was it half-hour period of time, 45 minutes, hour?
Approximately over an hour.
Were there, when you looked over, if you recall, was it one of those 2 states, or were there several times where you looked over and she did appear to be alert?
Those were the only times that I'd looked over.
So when you looked over during that period, it was either chin down or startling awake?
Yes.
Nothing else?
You said it was only during the playing of the video. Agreed?
Yes.
You understand that the video was less than an hour, correct?
Approximately an hour, yes, sir.
It's about 50 minutes.
Yes, sir.
So based upon that, you couldn't have been observing this for over an hour. Agreed?
I object that we played it for 56 minutes.
The record's
56 minutes.
It wasn't over an hour. Agreed?
Yes, sir.
And you can't tell the judge during those 56 minutes when you made the first observation. Agreed?
Agreed.
So you don't know if it was 15 minutes into the video, 30 minutes into the video. You can't say.
I cannot give an exact time, no, sir.
And all you do is, you said you saw it about this 4 or 5 times, correct?
Correct, yes, sir.
And you're not in a position to say whether her head was down for any continuous period of time. Agreed?
Agree.
That's all, Judge.
Thank you, Detective.
Thank you, Judge.
This is the lead detective on the case, Detective Schultz, who does not have a creek named after him.
Judge,
He did it with the Schultz Creek.
Video is obviously very important for the state's case. It was only played once. Clearly, we don't have enough time to play it again in closing, given the length of it. That would be our entire closing argument. Both sides are entitled to a fair trial with an attentive jury. So I think I'd ask that the court strike Juror 4021 as one of the alternates.
I don't think they've established a factual basis that she was sleeping. I think that there's reason to believe, but I don't think that they've established a factual basis of that.
I tend to agree. There are some clues to suggest that the juror may have been nodding off, but there's certainly nothing conclusive, certainly nothing that would allow me to make such a significant finding. I'll say, for my part, I was scanning the juror from time to time during the playing of the video as well. And my eyes were not fixed on them the entire time, obviously, because I'm trying to pay attention to the video, but I also was watching the jurors. I did not notice anything that would suggest somebody was sleeping. I have a different perspective than others. I'm not saying mine's better, it's just different. I did notice a number of occasions where people were looking down because they were writing on their notes, or they were averting their eyes, but they weren't sleeping. So I just say that to point out that there can be other alternative explanations for certain observations. The other point, too, is that even if we did have a sleeping juror, and even if that juror slept the entire presentation of the jail interview, it is a recorded interview. And if that juror ends up being one of the 12, that juror has the ability to request to watch the video. So it's not like live testimony that is lost forever. This juror, if they make it to the deliberation room, has the ability to view the video again and take that into consideration as part of her deliberations. So for those reasons, the request is denied. Is there anything else?
No.
All right. Anything else from the defense?
Interesting.
Just like a break before we get into openings.
We will, yes. All right, let's take a short break. We will resume at 8:45.
All right, so they take a quick break, and we're going to. We don't know if she's an alternate yet. We also don't know her age. We do know there is a breakdown of the ages that's been given, and we know that on the top end, as far as the most elderly juror, is 90 years old, and I believe that's a male. I believe it's a male, 90-year-old man, and then there's also I think a 70-year-old either man or woman as well. So there are, as far as age goes, it's a wide spectrum on this jury for sure. Melissa says this must happen a lot. Hang on one second. Okay. All right. I just had to deal with my kids with garbage trucks here, and I think our garbages are not taken out. This must happen a lot. I want to know where the writers of Jury Duty got their material for character Barbara. Oh, my goodness. I love Jury Duty. It has some parts I think they could have really cut out of that, but that is an amazing, amazing video other than that. Add more Perry Mason clapping and banging. I'll catch the recorded stuff later. It's nap time, baby. There goes the garbage truck. So missed it. We just can't have enough any more garbage this week. All right. If it's an older person, they will be more likely to say guilty, in your opinion. Possibility. The 90-year-old is a male. I can't fault this juror at all because I think I slept at the same time. Okay, I'm sorry. The audio was bad. They're talking about the interrogation video with the lady at the police station. With Mr. Mew at the police station with the female investigator. Let's see. She could be an alternate. It's possible. I think it's still random. The way the judge talked about this, the selection of the actual deliberating jurors is random. Okay, here's the breakdown. We've got two in their 20s, one in their 30s. Thank you, Michelle, for this, by the way. Two in their 20s, one in their 30s, three in their 40s, three in their 50s, one in their 60s, three in their 70s, and one in their 90s. Wow. So 20s to 90s, that is an incredible spectrum. Like a spread of, representation of the population. Our garbage truck comes 2 times a week, thank goodness. Man, they would double my prices if they did that. I missed that video. Tower Hill Girl, I slept through parts. It wasn't terribly enlightening. I'll tell you what happened. Mr. Muse lied in the video. He lied. He lied about, I think, them having another knife, like a kitchen steak knife. I mean, who goes and floats the river with a kitchen steak knife, right? It doesn't even make sense. A little pocket knife to cut through, yes, that would make sense. But kitchen steak knife, and inner tubes, it just doesn't match. You need a folding knife so it won't poke the tube. Let's see. I summed it up perfectly. That was pretty much it. He lied. And if this trial were about, this gentleman, Mr. Mew, lying to the police, I would say guilty, 100%. He did. He lied. He's guilty. But he's not being charged with lying to the police. At least it's not coming 1 a.m. and being very loud. It's not my fault you're in the wrong part of the world for the trials. I apologize for that. We get the recycle truck coming through today too. Ours comes tomorrow. Recycle comes tomorrow. We keep a kitchen knife on our boat for the limes, but do you keep a kitchen knife on your inner tube for the limes? I guess limes would work for this one as well. If they were like having Coronas or something. Curious where the 20-year-olds are. Judges are thinking about this, the juries. All the witnesses lied. Sheila, yes, everybody lied. I don't know. I don't know if everybody lied. Can you think of any witness that didn't lie, blatantly lie? It was probably going to be one of the experts, like the medical examiner. But even them, they seemed sort of one-sided and very opinionated as far as who was right and who was wrong. Not one person lived up to the oath, says Lizzie. Madison's transcript. I'm not sure if we have time to go over that. See the charges: first-degree intentional homicide, second-degree intentional homicide, first-degree reckless homicide, second-degree reckless homicide. Man. The one girl with red hair seemed more credible. The river nurse who tried to do a chest seal. She was good. She was really good. Nurse admitted to being buzzed. Almost everyone was buzzed. There's one person who was sober, right? The girl who said, I'm a recovering alcoholic, and she was sober on the river. Talk about a tough situation to be a recovering alcoholic and be hanging out with everybody who's at some stage of inebriation. Can't say that word this morning. Drunkenness. Mandy Strong says Judge Newman would focus on that moment in time, and in that moment in time, he was in fear for his life. It's on video, just my opinion. Mandy, I think you're right. I mean, I don't think we can subdivide those 14 seconds that all this happened further. I don't think you can break that down into different segments. I think that was one event, and I think he was in fear for his life. Let's see. getting some advice about going to DC. I'm curious, like if I were to park at the Braddock Road Station stop of the Metro line, do they pay people to watch my car? Or is that an extra fee? Just a horrible day on the water, a bad movie. It's terrible. That's why we call it the Bad Apple River Trial. Pull options, I can only do a maximum of 4. Fun little update. I changed out my headlights yesterday in my wife's car because my eyes aren't what they used to be. It's even across the room looking at the TV. The small words, which used to be very clear, are now a little blurry. And I don't think her eyes are what they used to be. So we changed out the headlights so we can see better at night. I used them for the first time this morning. And I'll tell you, nobody coming the other direction flashed their brights at me, like indicating that they thought I had my bright lights on. And I passed quite a few people, including police officers, and even was behind a police officer at one time. I didn't have any problems, but wow, I can see at night. It's beautiful. The headlights are great. I'm going to blind everyone. So, I also did research on the lights online, and they are the recommended, the brightest. Some people recommend as the brightest you're allowed to have, and some people say off-road only. So I'm not sure where the line is. It's the beginning of the end, Debbie. But after I changed out the light bulbs, it was so easy to change them out. I mean, I brought my wife out to watch me because, you know, if I'm going to break something, I want her to witness it. And look, not my fault. It broke. But I brought my tool set. I'm super proud of this because I've never owned a tool set like this in my life. But I got this Craftsman tool set, right? Fun little story about this. It's a 83 piece tool set. It looks massive, right? Like everything you could possibly need is in here. One half of it is just blank, right? It's just like nothing goes here. And the other half has all the nifty bits and pieces. Well, when I got it, and this is funny because the Weather Watch says something about testing the warranty. When I got it, this big 1/4-inch ratchet, which is a low profile ratchet, it's got some good ASMR qualities to it. When I got it, this ratchet would not accept any of the sockets. Like it's got a little button on the back you push, and it releases the socket, and you can add and remove it. It was jammed. It wouldn't. I was doing everything I could to try to get a socket to seat on here, and it would not seat. So I called this number. The toll-free number, called Craftsman, and like 20 minutes later, I got a person, which was a long wait, but I got a person on the line, and they're like, what kind of washing machine do you have or something? I had to fight through all the different brands of things that Craftsman sells, but I got a person on the line, and I was able to explain to them that the ratchet was not working, and they're sending me a new one. And as soon as they start sending me the new one, and I'm like, okay, thank you. I'm playing with it, and I break it free. Like there was something that was jammed in there, and it just starts working, and now it works beautifully. So I now have a brand new ratchet coming to me for free in the mail, and the old one is working fine. I don't know what the problem was, why it wouldn't work before. I don't know if it'll break again in the future, but now I have a bonus ratchet arriving. But I'm super, super excited. I've never had a tool set like that. I've had very, very cheap, like, the $5 tool set. I've had one of those, and all the pieces break and don't work and get lost. But so yeah, I was super excited. I used that tools kit to take apart the front of my car and take the headlights out, which let me count. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14 screws on the top, 15, 16, 17, 18. So a total of 18 screws had to be taken out, some in the wheel well, some in the front of the car, and 2 screws had to be loosened inside up in the wheel well behind the fairing, all to get to my headlights. And then I plugged in the new ones, and it worked. But all right. Anyway, so next project is the lawnmower with that same toolkit. Did you miss closing arguments? No, they were still sort of fighting over the jury instructions. They weren't quite done with that yesterday. Took a little longer than expected. You can lose better tools too. But now they're in a red box, and I'm not going to let anyone touch them, so they're all mine. I'm super excited. I told Mrs. R.A. that I would need to buy these tools to do the projects she has on my to-do list, and she gave me the go-ahead. And so it took forever to find the right toolkit. There are bigger toolkits and much more expensive ones by far. But this one was on sale and a good price and had the sizes I knew I would need. Yeah, about that many. That's how many screws there were. But man, it felt awesome to be able to fix something on my own car without paying somebody to do it. That's a first for me. Let's see. JS218, a user by Always On Go. Hey, welcome back with the new name, JS218. I'm not going to remember Always On Go. You're JS218 now for good. So good to have you here. Can you do a poll that is something like this? Greater than 40 guilty, greater than 40 not guilty, greater than 40 not guilty, greater than 40 guilty, please, for science. Are you talking about ages? Oh, you want over 40 and under 40, guilty, not guilty? Is that what you're talking about? Over and under? Okay. So this will be an interesting poll. We'll still watch for court. Nothing's happening yet in court, so we'll hear that as soon as it does. So this is very careful. You have to answer according to age. Here we go.
Judge, can we approach? Yeah. I'll just wait till they come in.
They're coming back.
Please be seated.
Why so much noise all the time? Okay, we're going to do the poll. Answer according to age. Under 40. Not guilty. You have to do not guilty first.
All right. Members of the jury, good morning. We are ready to deliver the jury instructions, and then the attorneys will make their closing arguments. Here's how the day will work. I will deliver the jury instructions to you. That'll take some time. I will have them displayed up on the board so you can follow along, but I will read them aloud in case you prefer to listen. After that, Mr. Anderson will deliver the state's closing argument. We'll take about a 15-minute break, and then Mr. Trofsy will deliver Mr. Mew's closing argument, and then the state will have the opportunity for a brief rebuttal. After that, you'll begin your deliberations.
Okay, answer according to age. The poll is up now. Are you over 40 or
Members
under 40?
of the jury, the court will now instruct you upon the principles of law which you are to follow in considering the evidence and in reaching your verdict. It is your duty to follow all of these instructions. Regardless of any opinion you may have about what the law is or ought to be, you must base your verdict on the law I give you in these instructions. Apply that law to the facts in the case which have been properly proven by the evidence. Consider only the evidence received during this trial and the law as given to you by these instructions, and from these alone, guided by your soundest reason and best judgment, reach your verdict. If any member of the jury has an impression of my opinion as to whether Mr. Mew is guilty or not guilty, disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the sole judges of the facts, and the court is the judge of the law only. The state filed an information that alleges that Nikolai Mew committed crimes in St. Croix County, Wisconsin on July 30, 2022. An information is nothing more than a written, formal accusation against a defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against Mr. Mew in any way. It does not raise any inference of guilt. In count 1 of the information, Nikolai Mew is charged with first-degree intentional homicide, and you must consider whether he is guilty of that offense. If you are not satisfied that Mr. Mew is guilty of first-degree intentional homicide, you must consider whether or not he is guilty of second-degree intentional homicide, or first-degree reckless homicide, or second-degree reckless homicide, which are less serious degrees of criminal homicide. The crimes referred to as first and second-degree intentional homicide and first and second-degree reckless homicide are different degrees of homicide. Homicide is the taking of a life of another human being. The degree of homicide defined by law depends on the facts and the circumstances of each particular case. While the law separates homicides into different types and degrees, there are certain elements that are common to each crime. Both intentional and reckless homicide require that Mr. Mew caused the death of the victim. First and second degree intentional homicide require the state to prove the additional fact that Mr. Mew acted with intent to kill. First and second degree reckless homicide require that Mr. Mew acted recklessly. First degree reckless homicide requires proof of one additional element, that the circumstances of Mr. Mew's conduct showed utter disregard for human life. It will also be important for you to consider the privilege of self-defense in deciding which crime, if any, Mr. Mew has committed. The Criminal Code of Wisconsin provides that a person is privileged to intentionally use force against another for the purpose of preventing or terminating what he reasonably believes to be an unlawful interference with his person by the other person. However, he may intentionally use only such force as he reasonably believes is necessary to prevent or terminate the interference. He may not intentionally use force that is intended or likely to cause death unless he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself. The words great bodily harm means injury which creates a substantial risk of death, or which causes serious permanent disfigurement, or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ or other serious bodily injury. There is no duty to retreat. However, in determining whether Mr. Mew reasonably believed the amount of force used was necessary to prevent or terminate the interference, you may consider whether Mr. Mew had the opportunity to retreat with safety, whether such retreat was feasible, and whether Mr. Mew knew of the opportunity to retreat.
No duty to retreat.
You should also consider whether Mr. Mew provoked the attack. A person who engages in unlawful conduct of a type likely to provoke others to attack, and who does provoke an attack, is not allowed to use or threaten force in self-defense against that attack. However, if the attack that follows causes the person reasonably to believe that he is in imminent danger of death or great bodily harm, he may lawfully act in self-defense. But the person may not use or threaten force intended or likely to cause death unless he reasonably believes he has exhausted every other reasonable means to escape from or otherwise avoid death or great bodily harm. As applied to this case, the effect of the law of self-defense is Mr. Mew is not guilty of any homicide offense if he reasonably believed that he was preventing or terminating an unlawful interference with his person and reasonably believed the force used was necessary to prevent imminent death or great bodily harm to himself. Mr. Mew is guilty of second-degree intentional homicide if he caused the death of Isaac Schumann with the intent to kill and actually believed the force used was necessary to prevent imminent death or great bodily harm to himself, but the belief or the amount of force used was unreasonable. Mr. Mew is guilty of first-degree intentional homicide if he caused the death of Isaac Schumann with the intent to kill and did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. Mr. Mew is guilty of first-degree reckless homicide if he caused the death of Isaac Schumann by criminally reckless conduct and the circumstances of the conduct showed utter disregard for human life. Mr. Mew is guilty of second-degree reckless homicide if he caused the death of Isaac Schumann by criminally reckless conduct. You will be asked to consider the privilege of self-defense in deciding whether the elements of first and second-degree reckless homicide are present. Because the law provides that it is the state's burden to prove all facts necessary to constitute a crime beyond a reasonable doubt, you will not be asked to make a separate finding of whether Mr. Mew acted in self-defense. Instead, you will be asked to determine whether the state has established the necessary facts to justify a finding of guilty for first or second-degree intentional homicide or for first or second-degree reckless homicide. If the state does not satisfy you that those facts are established by the evidence, you will be instructed to find Mr. Mew not guilty. The facts necessary to constitute each crime will now be defined to you in greater detail. First-degree intentional homicide, as defined in Section 940.01 of the Criminal Code of Wisconsin, is committed by one who causes the death of another human being with the intent to kill that person or another. In this case, first-degree intentional homicide also requires that Mr. Mew did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. Before you may find Mr. Mew guilty of first-degree intentional homicide, the state must prove by evidence that satisfies you beyond a reasonable doubt that the following elements were present. First, Mr. Mew caused the death of Isaac Schumann. The word cause means that Mr. Mew's act was a substantial factor in producing the death. Second, Mr. Mew acted with the intent to kill Isaac Schumann. Third, Mr. Mew did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself.
I'm closing the poll now. You'll have to watch chat for the results.
The words intent to kill means that Mr. Mew had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that Mr. Mew acted with intent to kill, it does not require that the intent exist for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from Mr. Mew's acts, words, and statements, if any, and from all of the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. while motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove Mr. Mew's motive in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. The third element of first-degree intentional homicide requires that Mr. Mew did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. This requires the state to prove either, 1, that Mr. Mew did not actually believe he was in imminent danger of death or great bodily harm, or 2, that Mr. Mew did not actually believe the force used was necessary to prevent imminent danger of death or great bodily harm to himself. When first-degree intentional homicide is considered, the reasonableness of Mr. Mew's belief is not an issue. You are not to be concerned. I'll start over. You are to be concerned only with what Mr. Mew actually believed. Whether these beliefs are reasonable is important only if you later consider whether Mr. Mew is guilty of second-degree intentional homicide. If you are satisfied beyond a reasonable doubt that Mr. Mew caused Isaac Schumann's death with the intent to kill, and that Mr. Mew did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself, you should find Mr. Mew guilty of first-degree intentional homicide. If you are not so satisfied, you must not find him guilty of first-degree intentional homicide, and you must consider whether he is guilty of second-degree intentional homicide, as defined in Section 940.05 of the Criminal Code of Wisconsin, which is a lesser-included offense of first-degree intentional homicide. You should make every reasonable effort to agree unanimously on the charge of first-degree intentional homicide before considering the offense of second-degree intentional homicide. However, if after full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of first-degree intentional homicide, you should consider whether Mr. Mew is guilty of second-degree intentional homicide. Before you may find Mr. Mew guilty of second-degree intentional homicide, the state must prove by evidence that satisfies you beyond a reasonable doubt that the following three elements were present. First, Mr. Mew caused the death of Isaac Schumann. Second, Mr. Mew acted with the intent to kill Isaac Schumann. Third, Mr. Mew did not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself. You have already been instructed on the definitions of causing death and with intent to kill. The same definitions apply to your consideration of second-degree intentional homicide. The third element of second-degree intentional homicide requires that Mr. Mew did not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe the force used was necessary to prevent imminent death or great bodily harm to himself. This requires that the state prove any one of the following. 1, that a reasonable person in the circumstances of Mr. Mew would not have believed that he was preventing or terminating an unlawful interference with his person, or 2, that a reasonable person in the circumstances of Mr. Mew would not have believed he was in danger of imminent death or great bodily harm, or 3, that a reasonable person in the circumstances of Mr. Mew would not have believed that the amount of force used was necessary to prevent imminent death or great bodily harm to himself. A belief may be reasonable even though mistaken. In determining whether Mr. Mew's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed. In Mr. Mew's position, under the circumstances that existed at the time of the alleged offense. The reasonableness of Mr. Mew's beliefs must be determined from his standpoint at the time of the acts and not from the viewpoint of the jury now. If you are satisfied beyond a reasonable doubt that Mr. Mew caused the death of Isaac Schumann with the intent to kill and did not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe the force used was necessary to prevent imminent death or great bodily harm to himself, you should find Mr. Mew guilty of second-degree intentional homicide. If you are not so satisfied, you must not find Mr. Mew guilty of second-degree intentional homicide, and you should consider whether he is guilty of first-degree reckless homicide, which is also a lesser included offense of first-degree intentional homicide. You should make every reasonable effort to agree unanimously on the charge of second-degree intentional homicide before considering the offense of first-degree reckless homicide. However, if, after a full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of second-degree intentional homicide, you should consider whether Mr. Mew is guilty of first-degree reckless homicide. First-degree reckless homicide, as defined in Section 940.02, Parent 1 of the Criminal Code of Wisconsin, is committed by one who recklessly causes the death of another human being under circumstances that show utter disregard for human life. Before you may find Mr. Mew guilty of first-degree reckless homicide, the state must prove by evidence that satisfies you beyond a reasonable doubt that the following three elements were present. First, Mr. Mew caused the death of Isaac Schumann. The word cause means that Mr. Mew's act was a substantial factor in producing the death. Second, Mr. Mew caused the death by criminally reckless conduct. Criminally reckless conduct means the conduct created a risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable and substantial, and Mr. Mew was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. You should consider the evidence relating to self-defense in deciding whether Mr. Mew's conduct created an unreasonable risk to another. If Mr. Mew was acting lawfully in self-defense, his conduct did not create an unreasonable risk to another. The burden is on the state to prove beyond a reasonable doubt that Mr. Mew did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all the evidence in this case that the risk was unreasonable. The third element, the circumstances of Mr. Mew's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, consider these factors: what Mr. Mew was doing, why he was engaged in that conduct, how dangerous the conduct was, how obvious the danger was, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. You should consider the evidence relating to self-defense in deciding whether the circumstances of Mr. Mew's conduct showed utter disregard for human life. The burden is on the state to prove beyond a reasonable doubt that Mr. Mew did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all the evidence in the case that the circumstances of Mr. Mew's conduct showed utter disregard for human life. Consider also Mr. Mew's conduct after the death to the extent that it helps you decide whether or not the circumstances showed utter disregard for human life at the time the death occurred. If you are satisfied beyond a reasonable doubt that Mr. Mew caused the death of Isaac Schumann by criminally reckless conduct and that the circumstances of the conduct showed utter disregard for human life, you should find him guilty of first-degree reckless homicide. If you are not so satisfied, you must not find him guilty of first-degree reckless homicide, and you should consider whether he is guilty of second-degree reckless homicide, which is a lesser included offense of first-degree reckless homicide. You should make every reasonable effort to agree unanimously on the charge of first-degree reckless homicide before considering the offense of second-degree reckless homicide. However, if after a full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of first-degree reckless homicide, you should consider whether Mr. Mew is guilty of second-degree reckless homicide. Second-degree reckless homicide, as defined in Section 940.06 of the Criminal Code of Wisconsin, is committed by one who recklessly causes the death of another human being. The difference between first and second-degree reckless homicide is that first-degree offense requires proof of one additional element, that the circumstances of Mr. Mew's conduct showed utter disregard for human life. If you are satisfied beyond a reasonable doubt that all of the elements of first-degree reckless homicide were present, except the element requiring that the circumstances of the conduct showed utter disregard for human life, you should find Mr. Mew guilty of second-degree reckless homicide. In other words, if you are satisfied beyond a reasonable doubt that Mr. Mew caused the death of Isaac Schumann by criminally reckless conduct, you should find him guilty of second-degree reckless homicide. If you are not so satisfied, you must find him not guilty. You are not, in any event, to find Mr. Mew guilty of more than one of those foregoing offenses. Mr. Mew is charged with attempted first-degree intentional homicide of Alexander Martin in count 2, Dante Carlson in count 3, Anthony Carlson in count 4, and Riley Madison in count 5. For each count, you must first consider whether Mr. Mew is guilty of attempted first-degree intentional homicide. If you are not satisfied that Mr. Mew is guilty of attempted first-degree intentional homicide, you must consider whether or not he is guilty of attempted second-degree intentional homicide, or first-degree recklessly endangering safety, or second-degree recklessly endangering safety, which are less serious degrees of attempted criminal homicide. The crimes referred to as attempted first and second degree intentional homicide and first and second degree recklessly endangering safety are different degrees of attempted homicide. The degree of attempted homicide defined by the law depends on the facts and the circumstances of each particular case. While the law separates attempted intentional homicides into 2 degrees, there are certain elements which are common to each crime. Both attempted first and second degree intentional homicide require that Mr. Mew intended to kill another person and Mr. Mew did acts toward the commission of that crime which indicate unequivocally, under all of the circumstances, that he had formed that intent and would have caused the death of the intended victim except for the intervention of another person or some extraneous factor. First and second degree recklessly endangering safety requires proof that Mr. Mew recklessly endangered the safety of another human. First degree recklessly endangering safety requires proof of one additional element, that the circumstances of Mr. Mew's conduct showed utter disregard for human life. It will also be important for you to consider the privilege of self-defense in deciding which crime, if any, Mr. Mew has committed. For count one, you were instructed on the law of self-defense. The same self-defense standards apply to your consideration of the charges of attempted intentional homicide that are alleged in counts 2 through 5. If you find that the elements of the crime have been proved in this case, the effect of the law of self-defense is as follows. Mr. Mew is not guilty of either attempted first or second degree intentional homicide or first or second degree recklessly endangering safety if he, 1, reasonably believed that he was preventing or terminating an unlawful interference with his person, and 2, reasonably believed the force used was necessary to prevent imminent death or great bodily harm to himself. Mr. Mew is guilty of attempted second-degree intentional homicide if he actually believed the force used was necessary to prevent imminent death or great bodily harm to himself, but the belief or the amount of force used was unreasonable. Mr. Mew is guilty of attempted first-degree intentional homicide if he did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. Mr. Mew is guilty of first-degree recklessly endangering safety if he recklessly endangered the safety of another human under circumstances that showed utter disregard for human life. Mr. Mew is guilty of second-degree recklessly endangering safety if he recklessly endangered the safety of another human. Because the law provides that it is the state's burden to prove all the facts necessary to constitute a crime beyond a reasonable doubt, you will not be asked to make a separate finding on whether Mr. Mew acted in self-defense. Instead, you will be asked to determine whether the state has established the necessary facts to justify a finding of guilt for attempted first or second degree intentional homicide or first or second degree recklessly endangering safety. If the state does not satisfy you that those facts are established by evidence, you will be instructed to find Mr. Mew not guilty. The elements of each crime will now be defined to you in greater detail. Before you may find Mr. Mew guilty of attempted first degree intentional homicide, the state must prove by evidence that satisfies you beyond a reasonable doubt that the following 3 elements were present. First, Mr. Mew intended to kill the named person. For count 2, the state must prove Mr. Mew intended to kill Alexander Martin. For count 3, the state must prove that Mr. Mew intended to kill Dante Carlson. For count 4, the state must prove that Mr. Mew intended to kill Anthony Carlson. For count 5, the state must prove that Mr. Mew intended to kill Riley Madison. Intent to kill means that Mr. Mew had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. The second element, Mr. Mew did acts which demonstrate unequivocally under all of the circumstances that he had formed the intent and would have caused the death of the named person except for the intervention of another person or some other extraneous factor. Unequivocally means that no other interference or, Unequivocally means that no other inference or conclusion can reasonably and fairly be drawn from Mr. Mew's acts under the circumstances. Another person means anyone but Mr. Mew and may include the intended victim. An extraneous factor is something outside Mr. Mew's knowledge or control. The third element, Mr. Mew did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. While the law requires that Mr. Mew acted with intent to kill, it does not require that the intent exists for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from Mr. Mew's acts, words, and statements, if any, and from all of the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing guilt of a defendant, the state is not required to prove Mr. Mew's motive in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. The third element of attempted first-degree intentional homicide requires that Mr. Mew did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. This requires that the state prove either, 1, Mr. Mew did not actually believe he was in imminent danger of death or great bodily harm, or 2, that Mr. Mew did not actually believe the force used was necessary to prevent imminent death or, 2, that Mr. Mew did not actually believe the force used was necessary to prevent imminent danger of death or great bodily harm to himself. When attempted first-degree intentional homicide is considered, the reasonableness of Mr. Mew's belief is not an issue. You are to be concerned only with what Mr. Mew actually believed. Whether these beliefs are reasonable is important only if you later consider whether Mr. Mew is guilty of attempted second-degree intentional homicide. If you are satisfied beyond a reasonable doubt that Mr. Mew intended to kill the person named in each count, Alexander Martin for count 2, Dante Carlson for count 3, Anthony Carlson for count 4, and Riley Madison for count 5, and that Mr. Mew's acts demonstrated unequivocally that he intended to kill and would have killed the named person except for the intervention of another person or some other extraneous factor, and that Mr. Mew did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself, you should find Mr. Mew guilty of attempted first-degree intentional homicide. If you are not so satisfied, you must not find him guilty of attempted first-degree intentional homicide, and you must consider whether Mr. Mew is guilty of attempted second-degree intentional homicide, as defined in Section 940.05 of the Criminal Code of Wisconsin, which is a lesser included offense of attempted first-degree intentional homicide. You should make every reasonable effort to agree unanimously on the charge of attempted first-degree intentional homicide before considering the offense of attempted second-degree intentional homicide. However, if after a full and complete consideration of the evidence, you conclude that further deliberation would not result in a unanimous agreement on the charge of attempted first-degree intentional homicide, you should consider whether Mr. Mew is guilty of attempted second-degree intentional homicide. Before you may find Mr. Mew guilty of attempted second-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 3 elements were present. First, Mr. Mew intended to kill the named person. Second, Mr. Mew did acts which demonstrate unequivocally, under all of the circumstances, that he had formed the intent and would have caused the death of the named person except for the intervention of another person or some extraneous factor. Third, Mr. Mew did not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself. You have already been instructed on the definitions of intent to kill, unequivocally, another person, and extraneous factor. The same definitions apply to your consideration of attempted second-degree intentional homicide. The third element of attempted second-degree intentional homicide requires that Mr. Mew not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself. This requires that the state prove any one of the following. 1, that a reasonable person in Mr. Mew's circumstances would not have believed that he was preventing or terminating an unlawful interference with his person, or 2, that a reasonable person in Mr. Mew's circumstances would not have believed he was in danger of imminent death or great bodily harm, or 3, that a reasonable person in Mr. Mew's circumstances would not have believed that the amount of force used was necessary to prevent imminent death or great bodily harm to himself. A belief may be reasonable even though mistaken. In determining whether Mr. Mew's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in Mr. Mew's position under the circumstances that existed at the time of the alleged offense. The reasonableness of Mr. Mew's beliefs must be determined from the standpoint of Mr. Mew at the time of his acts and not from the viewpoint of the jury now. If you are satisfied beyond a reasonable doubt that Mr. Mew intended to kill the person named in each count, Alexander Martin for count 2, Dante Carlson count 3, Anthony Carlson count 4, Riley Madison for count 5, and that Mr. Mew's acts demonstrated unequivocally that he intended to kill and would have killed the named person except for the intervention of another person or some extraneous factor, and that Mr. Mew did not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe the force used was necessary to prevent imminent death or great bodily harm to himself, you should find Mr. Mew guilty of attempted second-degree intentional homicide. If you are not so satisfied, you must not find him guilty of attempted second-degree intentional homicide, and you must consider whether Mr. Mew is guilty of first-degree recklessly endangering safety, as defined in Section 941.30 of the Criminal Code of Wisconsin, which is a lesser-included offense of attempted first-degree intentional homicide. You should make every reasonable effort to agree unanimously on the charge of attempted second-degree intentional homicide before considering the offense of first-degree recklessly endangering safety. However, if after full and complete consideration of the evidence, you conclude that further deliberations would not result in unanimous agreement on the charge of attempted second-degree intentional homicide, you should consider whether Mr. Mew is guilty of first-degree recklessly endangering safety. First-degree recklessly endangering safety, as defined in Section 941.30, Parent 1 of the Criminal Code of Wisconsin, is committed by one who recklessly endangers the safety of another human being under circumstances that show utter disregard for human life. Before you may find Mr. Mew guilty of first-degree recklessly endangering safety, the state must prove by evidence that satisfies you beyond a reasonable doubt that the following three elements were present. First, Mr. Mew endangered the safety of another human being. Second, Mr. Mew endangered the safety of another by Mr. Mew endangered the safety of another by criminally reckless conduct. Criminally reckless conduct means the conduct created a risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable and substantial, and Mr. Mew was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. You should also consider the evidence relating to self-defense in deciding whether Mr. Mew's conduct created an unreasonable risk to another. If Mr. Mew was acting lawfully in self-defense, his conduct did not create an unreasonable risk to another. The burden is on the state to prove beyond a reasonable doubt that Mr. Mew did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all the evidence in the case that the risk was unreasonable. The third element, the circumstances of Mr. Mew's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, consider these factors: what Mr. Mew was doing, why he was engaged in that conduct, how dangerous the conduct was, how obvious the danger was, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. We should also consider the evidence relating to self-defense in deciding whether the circumstances of Mr. Mew's conduct showed utter disregard for human life. The burden is on the state to prove beyond a reasonable doubt that Mr. Mew did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all of the evidence in this case that the circumstances of Mr. Mew's conduct showed utter disregard for human life. Consider also Mr. Mew's conduct after the act alleged to have endangered safety to the extent that it helps you to decide whether or not the circumstances showed utter disregard for human life at the time the act allegedly to have endangered safety occurred. If you are satisfied beyond a reasonable doubt that Mr. Mew recklessly endangered the safety of another, those named in each count: Alexander Martin for count 2, Dante Carlson count 3, Anthony Carlson count 4, and Riley Madison count 5. And the circumstances of the conduct showed utter disregard for human life, you should find him guilty of first-degree recklessly endangering safety. If you are not so satisfied, you must not find him guilty of first-degree recklessly endangering safety, and you should consider whether he is guilty of second-degree recklessly endangering safety, which is a lesser included offense of first-degree recklessly endangering safety. You should make every reasonable effort to agree unanimously on the charge of first-degree recklessly endangering safety before considering the offense of second-degree recklessly endangering safety. However, if, after full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of first-degree recklessly endangering safety, you should consider whether Mr. Mew is guilty of second-degree recklessly endangering safety. Second-degree recklessly endangering safety, as defined in Section 941.30, Parent 2 of the Criminal Code of Wisconsin, is committed by one who recklessly causes the death of another human being. The differences between first and second-degree recklessly endangering safety is that the first-degree offense requires proof of one additional element: that the circumstances of Mr. Mew's conduct showed utter disregard for human life. If you are satisfied beyond a reasonable doubt that all of the elements of first-degree recklessly endangering safety were present, except the element requiring that the circumstances of the conduct showed utter disregard for human life, you should find Mr. Mew guilty of second-degree recklessly endangering safety. In other words, if you are satisfied beyond a reasonable doubt that Mr. Mew endangered the safety of Alexander Martin, Dante Carlson, Anthony Carlson, or Riley Madison by criminally reckless conduct, you should find him guilty of second-degree recklessly endangering safety. If you are not so satisfied, you must find him not guilty. You are not, in any event, to find Mr. Mew guilty of more than one of the foregoing offenses for each count.
Sorry, Judge. Could we take a brief break, please?
Yes, please take the jury out.
All rise for the jury.
Who asked for the break? Something just happened here. Did we find an
Let's
error?
return in 5 minutes, 9:40. What's that? No, I just wait.
Can I move the podium now? No, you may not. You may not move the podium. All right, not sure what happened. I'm not sure what happened there, but possibly a juror sleeping. A juror maybe asked for a break. Someone behind the defense table, think a juror. Interesting. Was that juror 4021 who asked? That was the lady, I think, that was sleeping, apparently. It sounded like a man's voice to me. I didn't hear very well. We have either a code yellow or a code brown. I don't know. Something's going on. So interesting things. What I've drawn from this, this sounds very repetitive, right? These jury instructions, but especially when there are multiple charges or multiple offenses that are very similar, it sounds like the judge is reading the same thing over and over. And if you're not paying attention, it might be so. But there are some subtle differences in it. And he has to go through each of these instructions for each of the counts. So there are parts that are literally identical for each count. The takeaway here is that if that you as a juror are convinced that Mr. Mew acted in self-defense, you cannot find him guilty as charged. Okay? Now it's possible you could still say, but his actions were, the action he took was not reasonable, and then there's a lesser degree charge that he could be guilty of. But if you find that he was acting in self-defense, all you have to go on is based on what he believed. And at that time, basically, you would have to say, if I believe that he was acting in self-defense, I'd argue you believe what Mr. Mew said on the stand. And if you believe what he said on the stand, he was acting in self-defense. So you cannot find him guilty of the first charges as charged. The tricky part is that filtering down the next and then look at this next charge, then look at this next charge. They have to go through all these charges. It is a lot just listening. We're listening to it, and we've done this many times before, and it's a lot for us. Even looking at these papers and reading them over and over, this is like one of those mind games where like a train left the station going 60 miles an hour at this time. There's a lot here you've got to just sort of put together and almost like follow through a checkbox and say, okay, we've followed part one, and now we go to part two, and now we jump over here to section C. Very small details that all have to be followed. Jury asked for a break. Yeah, they're bathroom break. Cool. Bathroom breaks are cool. They're allowed to do that. So if the jury does not believe Mr. Mew, do they have reason? Maybe. Let's see. He lied to the police several times. I think he lied to his friends on the river. He has shown a pattern of lying. As a jury member, you might say, based on what I know about this gentleman, the evidence has been submitted, I don't believe what I hear from him. So if they choose to not believe his testimony, most likely they will then convict as charged, guilty as charged, which is the highest charge, and that shows intentional. Now, part of the problem there is the state has to prove that there was intent, and that is very difficult. That is very difficult, especially in showing that, in 14 seconds, all this happened in 14 seconds, and there was nothing other than running up on the tubes where he didn't have his knife out at the time, and he literally walked away after that. There was nothing showing intent at that point. So you're basically saying that a light bulb came on and that he had intent at that time. That's tough to prove. It's tough to prove. So I think if there is a conviction, it will be on a lesser here, just because of the difficulty of getting that to the charged offense. But everybody lied. Yes, everybody was lying. Oh my goodness! And part of the problem was that everybody was drunk to some degree for the most part. I think there was one or two people that were not drinking, whether they were a designated driver or in recovery or something like that. But most people were drinking, and it affected their memories. It affected how they processed the event. It affected how they acted at the event, and it affected their memory. Knife out early is intent to defend himself. Trying to think of a situation I've been in. Probably don't want to share them. I was going to share it. I was going to share a situation where I've been in, where I've had to defend myself. In a situation where I felt threatened, or I felt a situation was becoming threatening based on people's behavior. And I had means of defending myself at the time. I'll go into that. Won't go too far into that. He touched his knife before taking it out. He took it out down low so no one would see it. Well, it was down low, so he had to take it out down low. But he held it in front of himself. I mean, that's why it's in the video. You can see it plainly towards everybody before anything happened as far as the stabbing went on. He knew he had a deadly weapon. Mew had the responsibility. Legal weapon. There was nothing about owning or carrying a knife. I imagine if you polled the groups as they floated down the river by you in an average day, that better than 1 out of 4 groups would have a knife with them of similar type. For how long in the video did he have his knife out before using it? The knife out, the knife came out about the time he went in the river. So I think we heard in testimony yesterday, Mr. Mew said that he had taken his knife out and it was not open yet in his hand when he was knocked down. So he had taken it out at that point as people were approaching, but he had not opened it yet. And I think it was after he was knocked. No. Because the knife is out and open when he's facing the 2 girls, and that's before. So the knife is out before he gets knocked down. He gets knocked down, doesn't lose his grip, comes back up with the knife, and starts stabby. I don't know exactly when it came out, but it was during that time with the girls there. Okay, let's see if we get some audio back here. Just one second. Nope, not yet. Oh, let's see where we've got something coming back. No audio yet, but it looks like the jurors are coming back in. I will say that almost all his attacks on somebody, or the moves with the knife, were stabs, and that the injury was like a straight in, like a punch. With one exception, that was...
I think I speak for everyone in the courtroom. That was a well-timed break. Everyone ready to listen to the judge talk some more? All right. I'm picking up on page 20.
I'm going to get the timer right here.
All right. In count 6 of the information, the judge alleged that Mr. Mew committed battery. Battery, as defined in section 940.19, parent 1 of the Criminal Code of Wisconsin, is committed by one who causes bodily harm to another by an act done with the intent to cause bodily harm to that person or another without the consent of the person so harmed. Before you may find Mr. Mew guilty of this offense, the state must prove by evidence that satisfies you beyond a reasonable doubt that the following 4 elements were present.
Okay, sorry, I'm trying to sync everything up.
Judge, can we approach quick? Yes.
What? Trying to figure out why they're approaching here. Let's see if that syncs up right. The judge is confused. I think he started in the wrong spot.
Every lawyer loves to tell the judge he made a mistake. I made a mistake. In count 6 of the information, the state alleged that Mr. Mew committed battery. So let me get to the elements. First, Mr. Mew caused bodily harm to Madison Cohen. The word cause means that Mr. Mew's act was a substantial factor in producing the bodily harm. Bodily harm means physical pain or injury, illness, or any impairment of physical condition. Second element, Mr. Mew intended to cause bodily harm to Ms. Cohen. Intent to cause bodily harm means that Mr. Mew had the mental purpose to cause bodily harm to another human being, or was aware that his conduct was practically certain to cause bodily harm to another human being. The third element, Mr. Mew caused bodily harm without the consent of Ms. Cohen. The fourth element, Mr. Mew knew that Ms. Cohen did not consent. You cannot look into a person's mind to find intent and knowledge. Intent and knowledge must be found, if found at all, from Mr. Mew's acts, words, and statements, if any, and from all of the facts and circumstances in this case bearing upon intent and knowledge. The state must prove by evidence that satisfies you beyond a reasonable doubt that Mr. Mew did not act lawfully in self-defense. You were instructed on the law of self-defense in count 1. The same self-defense standards apply to your consideration of the charge of battery alleged in count 6. If you are satisfied beyond a reasonable doubt that all 4 elements of battery have been proved and that Mr. Mew did not act lawfully in self-defense, you should find him guilty. If you are not so satisfied, you must find him not guilty. The information alleges not only that Mr. Mew committed the crimes charged in counts 1 through 6, but also that he did so while using a dangerous weapon. If you find Mr. Mew guilty on any of these counts, you must answer the following question. Did Mr. Mew commit the crime while using a dangerous weapon? Dangerous weapon means any device or instrumentality which, in the manner it is used or intended to be used, is likely to produce death or great bodily harm. Again, great bodily harm means injury which creates a substantial risk of death or which causes serious permanent disfigurement or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ or other serious bodily injury. Before you may answer this question, yes, you must be satisfied beyond a reasonable doubt that Mr. Mew committed the crime while using a dangerous weapon. If you are not so satisfied, you must answer the question, no. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless in your deliberations you find it is overcome by evidence that satisfies you beyond a reasonable doubt that Mr. Mew is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that Mr. Mew is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with Mr. Mew's innocence, you must do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give Mr. Mew the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth and give Mr. Mew the benefit of any reasonable doubt that remains after carefully considering all the evidence in this case. You are to decide the case solely on the evidence offered and received at trial. Evidence is, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room. Third, any facts to which the lawyers have agreed or stipulated, or which the court has directed you to find. Anything you may have seen or heard outside the courtroom is not evidence. It is not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that Mr. Mew committed the offense before you may find him guilty. Evidence has been presented relating to Mr. Mew's conduct after the alleged crime was committed. Whether the evidence shows a consciousness of guilt and whether consciousness of guilt shows actual guilt are matters exclusively for you to decide. Remarks of the attorneys are not evidence. If their remarks suggested certain facts not in evidence, disregard the suggestion. An exhibit becomes evidence only when received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received is evidence whether or not it goes to the jury room. Attorneys for each side have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact an objection was made. By allowing testimony or other evidence to be received over the objection of counsel, the court is not indicating any opinion about the evidence. You, the jurors, are the judges of the credibility of the witnesses and the weight of the evidence. Disregard entirely any question that the court did not allow to be answered. Do not guess at what the witness's answer might have been. If the question itself suggested that certain information might be true, ignore the suggestion and do not consider it as evidence. The weight of the evidence does not depend on the number of witnesses on each side. You may find that the testimony of one witness is entitled to the greater weight than that of another witness or even of several other witnesses. In weighing the evidence, you may take into account matters of your common knowledge and your observation. Start over. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experience in the affairs of life. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability, of the witnesses and of the weight to be given to their testimony. In your determination of credibility, you must avoid bias, conscious or unconscious, based on the witness's age, race, national origin, religion, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors. Whether the witness has an interest or lack of interest in the result of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any, has been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or to discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same thing here. We've now reached the stage where the attorneys will deliver their closing arguments. Consider carefully the closing arguments of the attorneys, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given to you by the court. First, we'll hear from Mr. Anderson. When he's done, we'll take a short break. After that, we'll hear from Mr. Sharafazi, and then Mr. Anderson will be permitted to give a short rebuttal. Mr. Anderson.
All right, there goes closings. I think they have about an hour each. They have a PowerPoint. Better be good. We're keeping the cursive counter up because I think they might use a couple words during closings.
Absolutely senseless and horrific acts of violence. And all Nikolai Mew had to do was walk away. All he had to do was walk away. That's what you've seen in this case. You saw he told Lieutenant Hart, "They told me I can't run away." Obviously not true. Think about the result of his actions. Everything you've seen in this trial, the horrific injuries, the death of Isaac. Why didn't he just walk away? His only explanation when testifying was, "I stood my ground. I stood my ground." First of all, Wisconsin is not a stand your ground state. Objection.
Overruled.
I'll talk about that specifically from your jury instructions. Second, that's not true, as I'll show you. He didn't just stand his ground. I'm not going to defend the actions of the boys who testified. It was cruel what they were calling Nikolai. They shouldn't have been mocking him, calling him predator, raper. But their conduct did not justify what Nikolai did. You heard from Alina, Isaac's mother, about her son Isaac. He was 17 years old when he was killed. He enjoyed golfing, spending time with friends. He recently started a new business, detailing cars. He was an honor student looking forward to going to college. His death was senseless. One of the things defense said in the beginning of trial in their opening was they're glad there's a video. So are we. Without the video, Nikolai would have slipped away. The only reason he was apprehended was because law enforcement had that screenshot of him. The video doesn't fade with time. It's not biased, not influenced by alcohol. As I told you in the beginning of this case, the violent episode from the video is about 25 seconds, from the point he punches Madison until you see him walking off after stabbing 5 people. He's not seen, Nikolai is not seen in that video for 8 to 9 seconds until the point you see him walking away. You don't see him stab Dante. Some of you may have wondered why we called Marion Davis. Certainly wasn't for his eyewitness testimony, but he took a video. He took a video that captured a different angle than Juwan's video. It's grainy, it's difficult to see, but you can see enough. And it shows Nikolai seeking Dante out and stabbing him when his group is in the opposite direction. Nikolai walks into a crowd of people, stabs Dante. Before I show you that video again, I need to provide some context from Juwan's video.
Take it off.
We have the screen, please. So here at 2 minutes and 6 seconds, this is after Nikolai has stabbed the 4 people that you do see parts of on the video. He's standing next to Ariel. Ariel's there. Nikolai's not by himself. Two minutes, 8 seconds, that's the last you'll see of Nikolai until you see him walking off in this video. You see Dante, or AJ, the boys running back to their tubes, and you see Larian filming in the background. Larian captured what Nikolai was doing at this point, even though this video didn't. And here, in a moment, you can see the edge of Dante's swim trunks on the right. You can see the light on top, the dark on bottom. At this point in Larian's video, Dante's just been stabbed. Next, you see of Nikolai, he's walking off. You can see Dante in the background, holding his stomach, looking down at his wound. Take it down. Oh, actually, you can keep it up for a second, sorry. And then for further context, you see Alex Bang running to Isaac.
We have a very conservative cameraman today.
Let's see Larian's video.
Doesn't know if he should film it or not.
Okay, I have the screen. Remember, Nikolai admitted he walked up to he walked up to Dante and stabbed him. He admitted Dante was the last person he stabbed. Here you can see Nikolai, dark swim trunks, bigger build. On the right, you can see Dante, swim trunks, lighter on top, darker on bottom. You'll see Nikolai walk up to Dante and stab him in the chest. You'll see Dante recoil from the stab.
This is a hard video.
See the boys on the right running to their tubes. And in the second here, you'll see Alex Bang. You'll zoom in on him as he runs to Isaac. I'm going to show that again.
That's the only one I have a problem with.
So, a few things to know. There's nothing between Nikolai and Larian. He's not surrounded. His friend Ariel is there at this point. There's nothing to the left and behind Nikolai, except his group in the distance that you can't see on video. He walks away from those directions towards a group of people and stabs Dante in the chest, not standing his ground. He's seeking out Dante. That's retribution, not self-defense.
And recall too the DNA results. Isaac's DNA and Dante's DNA was the only DNA on the knife. They're also the last two that are stabbed. It makes sense from how the analyst described DNA and how it can wash off. You probably noticed throughout this trial, not a lot of witnesses come off looking great after they testify. There's some exceptions. Obviously, the Good Samaritans who went to aid Isaac and AJ. Eric Von Williams included in that from Nikolai's group. He's the only one who went to their aid. Sheena Lowell, you heard her testify from the Carlson group. You saw her just standing in the background watching what was going on the whole time. She was completely sober. You heard her testify, Nikolai punched Madison. She has zero connection with the group anymore, zero contact. Her and Quentin broke up. Tony is another one. He only comes in to break up what he thinks is a fist fight. He's directing Nikolai towards Nikolai's group. Nikolai turns and stabs him twice. Another one I submit to you is an exception that acted admirably is Isaac. His death was tragic and horrific. This is what you see of Isaac in the video. On the left, he's standing next to his tube, not moving away from his tube. He's pointing at Nikolai to leave. In the middle, when Nikolai turns back to Isaac, Isaac puts his hands up, fingers splayed. The only other thing you see of Isaac is him standing in the background. When the other boys are mocking, calling names to Nikolai, Isaac is just standing in the background. He's not saying anything. He's not doing anything. He's not jeering. He's just standing there holding their tubes. There's been a pretty serious mischaracterization of Isaac's actions with regard to when he gets stabbed. Defense has tried to classify it as a strangulation. Defense accused the state in openings of being selective in the photos we used, the frames, to try to show a certain narrative about Nikolai smiling. As you've seen, he's smiling a lot in the video. But defense is actually doing that when it comes to Isaac. Nikolai never said anything about being choked, never said anything about pain on his neck, even when specifically asked by the start nurse, never mentions anything. And the video doesn't lie. So on the left, Nikolai has just stabbed Riley, who you heard from multiple witnesses who are just standing there. Tony comes to try to break it up. Nikolai stabs him twice.
Cameraman
Isaac,
2 beers.
Just off frame, I submit to you, he just saw Nikolai stab those two people completely unprovoked. Although he was in the background the whole time, not doing anything, he came to their aid. And he pushes Nikolai. You can clearly see it's a push. He has one hand on the arm, other hand on the chest. It's Nikolai's own action of thrusting the knife into Isaac's heart that moves Isaac's hands. You can even see from the release, it's a push. He's not sitting there left holding his hands out in a choking motion. Let me take the screen down.
Yes.
I'm going to show you the video so you can see it's obviously a push. While my computer is loading here, even if it was a strangulation, which it clearly isn't, Isaac was justified in using any level of force. He just saw Nikolai stab two people who posed no threat to Nikolai. Tony was breaking up the fight. He had actually ignored Nikolai at first, walked past him, pushed Dante out of the way. Riley was just standing there. I'm at 2 minutes and 3 seconds. Can we have the screen? Clearly a push. Defense has mischaracterized the entire situation as 13 on 1, 13 on 1, implying it's some sort of mob beating up Nikolai. It's not even 13 people yelling at Nikolai. As you saw in the video, Gabby, Janelle, they're just standing in the background. Isaac, he's just standing in the background, not yelling anything. It's 13 people in the proximity, only 2 close to him, 2 tiny females. Nikolai's clearly not afraid of the boys. He ran up on the boys, turns his back on them and others multiple times. Even at worst, this is a 2-on-1 with AJ and Dante. But even then, as you saw in the video, Ariel's right there. It's more like a 2-on-2. Ariel's right there. Plus, Tony comes in as a neutral party to separate things. It's not 13 on 1.
Hey guys, no name calling in the chat.
AJ,
let's be polite
gets
to everybody.
Disemboweled. You see people start to move away. So it's not, there's not even 13 people immediately around. You saw Owen way in the background because he saw the knife. So why try to mischaracterize the situation? Because there's some things that are hard to explain otherwise for defense. Turn on the screen, please. This is the second time you saw in the video that Nikolai turns his back on the boys and people from the Carlson group. You don't turn your back on somebody. It's common sense. You don't check your common sense at the door when you serve as a jury. You don't turn your back on somebody if you're afraid of them, especially if you're so afraid you got to reach for your knife. You can't be that afraid that he's got to reach for his knife and so unafraid that he turns his back on them. He was angry, not afraid. That image on the right is only less than 30 seconds after he turns his back on them, touching his knife. The defense tried to explain that change from in that 30-second window by saying he was getting pushed by Madison and Riley. He was getting pushed. They're lightly touching his arms and they're tiny. They're not in his face. You can see in the images, they're standing close. They're not in his face. They're not shaking their fists at him. They're not even sticking their fingers in his face. They're standing close to him, touching his shoulders, pointing, yelling at him to leave. I'm going to back up a little bit and talk about Nikolai looking for the phone. So Eric Von Williams from Nikolai's group, you heard testify, before any of this happened, he was concerned about Nikolai's behavior. He was concerned that people were going to think he was a predator. Ernesto told Nikolai not to go look for the phone. Others in the group told him not to. You heard they didn't care about the phone. Ariel didn't care about the phone. Nikolai went. Sandy said he went twice, was back for 5 to 10 minutes, then went again over by the boys. Defense argued in opening that the boys' goal, their goal was to humiliate Nikolai. Clearly, he wasn't looking for little girls. But the boys are not completely unreasonable in their belief. Eric Von Williams thought the same thing. They reacted wrong, but they just didn't invent this whole thing in order to humiliate Nikolai. What about Nikolai, 52 years old, apparently sober, according to, I think, what defense will argue. He didn't have any signs of intoxication when law enforcement made contact with him, but he certainly made a point of telling Lieutenant Hart multiple times how much he was boozing and drinking on the river. He can't let it go that he was insulted. So much so that as the boys are tubing away from him, all Nikolai has to do is stand there. He doesn't even have to take a step back. He just has to stand there, let the boys continue tubing. They're down in their tubes. He starts walking up to them, touches his knife, and then runs up to them. You heard Nikolai's ridiculous description or explanation for why he ran up on the boys. Because one was holding a phone, he thought it was Ariel's phone. You also heard Nikolai had to concede, had to admit that pretty much everyone on the river had those phone cases. Another double standard from defense is physical attributes of those involved. They wanted to elicit evidence that Nikolai is feeble. Sandy, he wasn't feeble according to Sandy. He had a surgery a couple years ago, recovered in a few weeks. Maybe things took him a little longer than they did before. He wasn't feeble according to Ernesto. You heard Ernesto, when he was being asked about the stabbing, said, he's a big guy, he was in the Army, he doesn't need a knife to defend himself. He didn't say, oh, he's this fragile old guy. He's clearly not feeble, as you see in the video. He runs up on these boys in the water. He leaves behind devastating, devastating injuries. Slices clean through 2 of Isaac's ribs. He comes out of the whole event essentially uninjured. While defense tries to argue that Nikolai is this feeble old man, they ignore that the only 2 people actually standing close to Nikolai are these 2 females that are barely over 100 pounds. If the boys are a threat, why does Nikolai run up on them? And clearly he knows they're not a threat to him. When he ran up on them, grabbed their tubes, standing over them, they did nothing. They didn't kick up at him, they didn't punch at him, they jumped out of their tubes and moved away from him. He knows they're not a threat to him. They're mocking, saying cruel things, but not violent.
I think that's possibly Nikolai's brother.
You saw how awkward it was for Nikolai to try to explain this transition. From 0 fear to 10 out of 10 fear, he's got to take out his knife. Try to explain it with what I submit to you is obviously rehearsed testimony about his scales of fear. You heard from witnesses recounting what they recall of Nikolai, the demonic look on his face, staring through people, smirking. Defense argued in opening it's a slide tour here, there. You know, after seeing the video so many times, that's not the case. When he's not glaring, he's smirking in the video. Recall, I asked Ernesto, his best friend, when he was trying to describe the shock of Nikolai, I asked, was he smiling? He didn't say, yeah, he smiles when he's scared. He smiles when he's nervous. He said, who's going to smile in a situation where they're in shock or in fear? Nikolai was angry. He wasn't afraid. He's smirking even as he's holding the knife. Why didn't he just walk away? Defense tried to argue there's rocks unstable, his sandals were bad, didn't stop him from running up to the boys as they're tubing away from him. Why didn't he just hold the knife up? Say, hey, I got a knife, back up. You saw, Owen is the only person who saw the knife and you saw his reaction. So everyone else is moving forward and respond to Nikolai punching Madison. Owen's trying to pull people back. Next you see him, he's off in the distance. This whole thing would have ended if Nikolai just held up the knife. Instead of opening it down by his waist without looking down, because it's human nature, if he would have looked down, people would have looked down. He holds it down by his waist, opens it up, never displays it, or says he has a knife. Nikolai did not act as any reasonable person would in that situation if they were truly in fear of their life or great bodily harm. So let's talk. Here's Owen reacting, as you see. Again, Isaac just standing in the background in the middle. You see when other people are moving forward, Owen's trying to pull them back. You heard him yell, bro, he's got a knife. So let's talk about the punch to Madison. I submit to you the evidence shows clearly, beyond a reasonable doubt, Nikolai punched her. She fell backwards, but caught herself. Multiple witnesses testified to seeing her falling backwards. Defense is saying, arguing on cross, well, she's not wet. She didn't actually fall down. If witnesses are all standing in that kind of semicircle around Nikolai, she gets punched and falls backwards, and then their attention's back to Nikolai as Dante's hitting him. They're not going to see that she caught herself. They're going to think she fell down. Look at her position next to Riley. They're shoulder to shoulder in front of Nikolai before the camera pans away. When the camera pans back, now Dante's shoulder to shoulder with Riley, and Maddie is back. She clearly got knocked backwards. Her sunglasses aren't on her head anymore. Defense has a double standard about that too. If there's not a photo of it, it didn't happen. If there's not a photo of an injury, it didn't happen. We know Nikolai got punched. He didn't have any injury. Defense can't have it both ways. So I'll turn and talk a little bit about memory, credibility. Obviously, a witness's memory is better closer to the event. That's obvious. Alcohol is going to affect memory. Traumatic events can affect memory. How fast it happens is going to affect memory. But crucially, and absolutely crucially, there's a huge difference between getting some details wrong, right hand, left hand, sequence of events,
he discredited
and
a lot of his own
making up an
witnesses.
entire story like Nikolai did. Defense has tried to highlight throughout the trial, Nikolai was in this traumatic experience, give him a break. It's understandable, he made up all these lies, told this whole story. Even though he looks calm and collected in the videos, he's convincing in the videos, talking to the sheriff, talking to Lieutenant Hart. But don't give any sort of credence to the theory that trauma affects memory for anyone in the Carlson's group, any of the boys, any who were stabbed, any who had to drag Isaac as he's bleeding to death to the shore. AJ, who was disemboweled, don't give any credence that trauma might affect their memory and how accurately they can remember all the details. But Nikolai, who invented an entire story, tried to skip through the crowd. Give him credence for that. You saw what happened to all these witnesses, how fast it happened. It's not surprising, some of the details are wrong. But the major point is accurate, is consistent. This all started when Nikolai punched Madison, whether it was the right hand or left hand. You heard the turmoil of the boys when they realized Isaac is stabbed. Clearly a traumatic experience. There's a big difference between details and invention. Think about the most basic example. You and, say, your partner go to the grocery store. Park your car, you're leaving the grocery store. You think your car's parked over there, they think it's parked over here. You still know the car is parked in the parking lot, even if you can't remember where it's parked. The same is true for the punch to Madison. You heard from 10 people, both from the Carlson group and the Boyd's group, that Nikolai struck Madison.
Yeah, that car park thing didn't do it for me.
So let's talk a little bit about witnesses from Nikolai's group. Ariel, what did he say? At trial, he says Nick defended himself. Can't really say how. Never said that when interviewed with law enforcement. He denied even being close to Nikolai. Remember, Ariel was there when he stabbed Dante. He was right there when Nikolai stabbed Riley, Tony, and Isaac. Law enforcement went there with the frame of Ariel standing next to Nikolai when Nikolai has the bloody knife. Ariel denies seeing anything to law enforcement of what Nikolai did. Ernesto, at trial, testified he didn't see Nikolai get hit, just saw him down in the water. Said he couldn't remember Nikolai saying, "They took my knife." You saw on the body cam, he said that repeatedly. He testified that somebody was walking towards him, he pointed at him, "Get back." Never said that to law enforcement, although he did describe to law enforcement, as you saw, him saying, "Nikolai, get out," Nikolai walking out, and then he said, and that's it. Never said anything about anyone pointing at him and walking towards him. When I asked, he said, I wasn't asked that question. But he described that event. He also wasn't asked more than 10 times if Nikolai said they took my knife. So, about the punch to Madison again. Sergio, he's in Nikolai's group. He had walked out a little ways. You can see him in the photo on the left, in the top right. He had the white shirt, white bucket hat. He testified he saw the blonde girl in the black leotard walk over to Nikolai and say, "Go, go, go." He said it repeatedly to law enforcement. And he said Nikolai pushed her. So this is what it would have looked like from his perspective, although a lot farther back in that photo on the right. How could he have seen Nikolai do anything to Madison unless she got pushed back, punched back, something violent, not some light push? He's not going to see that from where he was. Madison testified, and you saw in the video, after she was hit, she goes back to her group. Why would she walk away back to her group if Nikolai just lightly maybe touched her, maybe didn't? She told Quentin she was punched. She told police at the scene she was punched. She told police in the interview she was punched. She testified about feeling the throbbing pain in her cheek, her heartbeat in her cheek. Maddie testified she was told by law enforcement, sheriff's office, they didn't need the photo. You heard about that misunderstanding. She had anxiety about deleting the photo. In an effort to console her, she was told, "Don't worry about it." This is an important jury instruction in your jury instructions. Although we're not a stand your ground state, there's also not a duty to retreat. But in determining whether Nikolai's actions, whether his use of force was reasonable to prevent or terminate the interference, you may consider whether he had the opportunity to retreat with safety, whether such retreat was feasible, and whether he knew of the opportunity. He turned his back on them multiple times facing open water. People were yelling at him to leave, to walk away, to go. And he didn't. Instead, he took out his knife. That is not reasonable. You heard from Sheena Lowell, Janelle Duxbury, Ghazi Khazri and Nazimpour, Dante Carlson, and AJ about the strike to Madison. You heard from the boys, Ryan Nelson, Juwan Cockfield, Landon Wire, and Alex Vang. Alex Vang originally described him as a slap. You heard from Owen that he heard an impact and saw Madison fall back and catch herself. Defense has to argue that they're all either lying or mistaken. All these witnesses, including Sergio. If they're lying, why would Quentin say, "I saw some swelling and some slight redness, but didn't see the punch"? Why wouldn't he just say, "Yeah, I saw the punch too"? Why wouldn't Tony say he saw the punch? Why wouldn't Tony say he saw Riley get stabbed and she's just standing there? They tried to explain what happened as best they could remember. The punch isn't on video, but you see the reaction. You hear Dante yell, "You can't hit a woman before Riley is stabbed." They obviously didn't plan this lie in the chaos of the moment. So the only thing defense can argue is they're mistaken. That all of these people standing around Nikolai in that half circle, proximate shape, They're all looking in that direction, including Sergio, including Sheena, who was by the group, the tubes for the crossing group. They all were wrong in what they saw. Another defense double standard, it's relatively minor, but I submit to you it shows that they're grasping at straws, is this trying to put Nikolai's group in a different category. There's the drunks on the Apple River, then there's Nikolai's group. About half of you raised your hand that you've been on the Apple River. That's what people do on the Apple River. They go up, they tube, and they drink. Nikolai was in the exact same boat they were in. He wasn't bird watching and this group of drunk teenagers ran up on him. He knew what it's about. He'd been on the river before. Another thing about the punch to Madison. You heard that they didn't get to see the video before giving their statements. Even Jawan, who took the video, said he got far enough to get the screenshot of Nikolai, and then law enforcement took his phone. He didn't get to see the video. You saw what happens in this case if somebody lies about something that happened on video, because Nikolai got burned by that. He made up complete and total lies. Video showed he wasn't telling the truth. The video happens to not show the punch, but it still corroborates what all those witnesses said. So, count 6 is battery to Madison Coleman. It has 4 elements. Nikolai caused the battery to Maddie, or caused the injury, the harm, the pain. She testified to that. He intended to cause the harm, despite his denial. I submit to you that's clear. You don't punch somebody without intending to cause harm. She didn't consent. She testified to that. He knew she didn't consent. She's a stranger. Obviously, she didn't consent. He knew that. Punching Madison was not self-defense. Again, there's no duty to retreat, but you have to consider the opportunity to retreat, the knowledge of the opportunity to retreat, and whether the use of force was necessary in preventing the unlawful or the interference in Nikolai's person. So what is the interference at the time he punches Madison? The boys are saying cruel things to him. Maddie and Riley are standing in front of him, lightly touching his shoulders. People are pointing and laughing at the boys. They're not, Maddie and Riley aren't in his face. They're standing close, but they're not in his face. What amount of force was necessary to prevent that interference? People yelling at him, Maddie and Riley standing close. What amount of force was necessary? Absolutely zero. Just walk away. That's what people are yelling at him to do, just walk away. Instead, he takes out his knife and punches Madison. Regardless of whether you were convinced beyond a reasonable doubt it was a punch, Nikolai essentially admitted to pushing her. Sergio said it was a push, although when asked, he couldn't remember if it was a push or a punch. There's still provocation. Your jury instructions talk about provocation and how that affects self-defense. A person may not use or threaten force intended or likely to cause death unless he or she reasonably believes he or she has exhausted every other reasonable means to escape or otherwise avoid death or great bodily harm. Remember, Nikolai ran up on these boys who were tubing away. They didn't run up on him. He ran up on them as they're tubing away from him because they insulted him. He was angry. He didn't walk away from the boys to leave the situation. He went over to Maddie, who was yelling at him to leave, and he lies to her and says, "They took my snorkel." I'm going to play that for you so you can hear it. All right, this is at 105 in the video. I'm ready.
Altercations, go! Go! Altercations, go! Go! Altercations, go! Go! Doesn't matter.
You didn't. You can take it down. He didn't go over there to extricate himself from the situation. He went over there and accused the boys of taking his snorkel, which was a lie. And he had just ran up on the boys. So after he runs up on the boys as they're tubing away, he goes and tells Maddie they took my snorkel. He's standing there smirking at people, takes out his knife, either punches or pushes Maddie. That's provocation. Defense has zero reasonable argument, especially when it comes to Tony, Riley, Isaac, and Dante. Nikolai gets punched. He gets struck with an open hand twice. He gets ineffectually pushed by AJ. It doesn't do anything. Nikolai pops right up and disembowels AJ. After Nikolai goes down in the water, nobody approaches him. Nobody. Nobody goes to kick him. Nobody goes to punch him. Nobody goes to push him again. Tony, with Nikolai down on the ground, Tony walks by Nikolai with his back to Nikolai, yelling, "Get back to Dante." He turns around to tell Nikolai to get away, and Nikolai turns around and stabs him. Nikolai was facing his group with an open path of escape after provoking a reaction. He just stabbed Riley before stabbing Tony. After stabbing those two, he stabs Isaac. After that, after Ariel's there, he walks over to Dante, stabs Dante in the chest, right below his ribs, right below his heart. So self-defense. I submit to you the state has proven beyond a reasonable doubt this was not justified self-defense, and Nikolai knew it. He knew it from the moment he did it. First of all, imminent threat of death or great bodily harm. He's not in an alley with no way out, with people blocking his exit. He's on an open river, 150 feet wide, people yelling at him to get away. None of them are armed. Punch, 2 open hand strikes, ineffectual push. Look at the definition of great bodily harm, whether he reasonably believed death or great bodily harm was imminent. For attempted first-degree homicide for Dante, AJ, Tony, and Riley, the state has to prove that he intended to kill each of them. And the acts demonstrate unequivocally, under all circumstances, that he had formed the intent and would have caused the death of each of them, except for the intervention of some other person and an extraneous factor. Third, the defendant not actually believed that the force used was necessary to prevent death, imminent death, or great bodily harm. So for the intent to kill, but for outside circumstances. AJ, it's beyond clear. He would have died but for the blood in the helicopter. He would have died but not for the surgery Dr. Meyer performed. He is lucky, extremely lucky to be alive.
Hey, chat, let's focus on the testimony we've heard and
what else was Nikolai's intent but to
the
kill.
attorneys are saying to the jury. Let's not do the shaming
He
and
had
the
the knife
name calling.
Blade up. That wasn't an accident. He did not know. The first thing he does with it is slice up AJ's stomach. Riley, he slashes across the ribs. You saw the horrific nature of those wounds. He cut into her stomach, cut into her diaphragm. Luckily, he didn't hit any major arteries or her heart or lung. Tony blocked one stab, so Nikolai stabbed him again. When he blocked, you saw the injury was very close to where AJ's artery was severed. Dante was stabbed again, just below his heart. But for Nikolai missing vital organs, but for medical intervention. Mew claimed he had tunnel vision. Oh, sorry, back up. So Dr. Meyer also testified, you heard about anytime there's a puncture wound to the torso, stomach, they have to go in because there's so many major veins, arteries, organs, they have to go in to make sure something major isn't done. Nikolai killed Isaac, almost killed AJ. Riley needed emergency surgery. Luckily, but for dumb luck, missed the vital organs of Dante. But for AJ blocking one strike and missing vital organs, he survived. Nikolai said he had tunnel vision. I thought everyone close to me was attacking me. I thought anyone touched me was attacking me. He didn't stab Ariel, and Ariel came up. Makes the tunnel vision claim a little bit unconvincing. For first-degree intentional homicide of Isaac Schumann, Nikolai stabbed him so hard he cut clean through 2 ribs. The wound was deeper than it was wide. He sliced Isaac's heart. There's no other intent when you stab somebody directly in the heart than to kill. An intent to kill doesn't need to be planned ahead of time. Your jury instructions talk about that. It doesn't have to be formed a week, a month, a day, even a minute in advance. As long as he had that intent when he does the act, that's intentional homicide. The first element is he caused Isaac's death. That's obvious. Acted with intent to kill. I've addressed that. Did not actually believe the force was necessary to prevent imminent death or great bodily harm. I'm going to get to that in a little bit for all the counts. Third element, he did not reasonably believe the force was necessary. That also goes to, I'm sorry, that's part of the third element. So how do we know, how can what Nikolai believe? What a reasonable person would believe. That there's only one person on the planet who experienced what Nikolai experienced, saw what he saw, was standing in his place. And what did Nikolai believe? He believed it was unjustified. The very first thing he does is walk away. Doesn't run. Doesn't tell Ariel or Ernesto anything. Doesn't tell them to run. He walks away from his group to the other side of the river. At some point rinses the knife because it wasn't covered in blood. Throws the knife onto the bank before walking back to his group. Says nothing to his group other than they took my knife. Puts on his hat, sunglasses, and shirt, and sits down in his team. He's the one, as he said in his interview, who says, let's go, let's get out of here. They can't right away because Eric isn't there. You saw, and as they're tubing down the river, you saw the video of him casually paddling along. You saw, so plan 1, get away. Slink away with the crowd. That didn't work. Plan 2, play dumb. Can you take the screen down, please? Okay.
Camera recording started.
I wonder if they're recording this.
Still doing all right?
Yeah.
Okay.
What's going
Temperature?
on?
Temperature's okay in here?
Yeah.
Okay.
Somebody,
All right.
I hear somebody got stabbed. And I fit the description.
Yes, you do.
All right.
Yep. So we're working through that now. Did you see that fight on the river?
I heard about it.
You heard about it?
Yeah, and I seen people gather around it.
Okay. All right.
And I went over to talk to see if somebody saw anything, but that's about it.
Okay.
Our whole group was pretty interested in finding out what happened.
Okay. And that's your whole group over there?
Yeah.
Okay. All right.
So I don't know. Okay, well.
Did you see anybody injured?
No.
You didn't see anybody injured?
No.
Did you see anybody fighting?
I heard people screaming at each other, yes.
Okay.
Yeah.
Screaming in anger or screaming in pain, do you know?
everybody's drunk, so I don't know. I can't tell the difference, but I would say, I don't know, just screaming.
Okay.
You know, yeah, calling each other names, but that's, I've seen that all day. And we've all been drinking a lot. I'm sure they're drunk. I'm sure they're doing, I don't know, kids being kids.
Kids being kids. Where are you? Where's your group from? Where did you drive from today?
Sure, they're drunk, kids being kids. That's what I told Sheriff Knudsen, and he's acting like he has no idea what's going on. Clearly not in shock. You can take it down, sorry. Clearly not in shock. Clearly Nikolai knows that was not justified, and he's looking out for Nikolai. Slinking away didn't work. Plain dumb didn't work. He's told he's under arrest for homicide. Plan 3. Completely lie about what happened as to justify him using lethal force. The boys pulled out the knives. They twisted their arm, poked him. That's what he used, poke, with their own knife. So first degree intentional homicide and second degree intentional homicide are very similar. For first degree, did Nikolai actually believe? Did he actually believe that he was not justified? For second degree, it's the reasonable person standard. I submit to you, it doesn't make a difference in this case. It's crystal clear. He knew he wasn't justified. He knew he wasn't justified. It's crystal clear from his actions after the fact. Can't be explained away by shock. He's clearly not in shock. The use of force on AJ, stabbing Riley just standing there, stabbing Tony trying to break it up, stabbing Isaac directly in the heart. Ariel's there, walking up to Dante and stabbing him. The injuries he left behind, that all shows his intent. Again, you have to consider whether he knew he could retreat, whether there was a safe escape. He could have just walked away. He could have just raised his knife. He didn't do any of that. He just stood there with the knife until he punched Madison. He touched his knife when running up on before running up on the boys. He takes out the knife, opens the blade up, never says anything, never walks away, never takes a step back, never raises the knife, never yells for help. He's smirking with the knife in his hand. Finally, after stabbing 5 people, then he walks away. Doesn't run, walks. It's shocking to see what Nikolai did in this case, to see the injuries, and then see his calm, cool demeanor after the fact, tubing down the river, sitting in his tube at the scene with chaos, casually talking to Sheriff Knudsen, making up this huge lie to Lieutenant Hart. He even lied to the Startners at 9 p.m., so 5 hours after the incident, about the boy pulling a knife, twisting his arm, poking him with his own knife. He even lied to Sandy after the arrest. Nick recognizes that what happened is not justified self-defense. Just standing there with the knife, not walking away when you clearly can. So even to Sandy, after he's charged, he casts blame on her and the group for not hearing him yelling. He never yelled. Normally, it'd be difficult to know what a defendant believed in a self-defense case, not in this case. Nikolai was not in fear, he snapped. He was angry and he snapped, and he knew it. His actions show he knew he did not reasonably believe the amount of force was necessary. He was not actually in fear. If he was actually in fear, he would have left. How else? You know, what other clues? Think about his testimony. We submit to you that this is first-degree intentional homicide and first-degree attempted homicide. His acts clearly show intent. But if you can't agree unanimously on that, as your jury instructions tell you, you have to consider second degree. Again, the difference in second degree is Nikolai's belief versus reasonable person. Here you know, I submit to you, his belief from his own conduct. Afterwards, he knew it was not justified. If you can't agree on second degree, you consider first degree reckless homicide, first degree reckless endanger of safety. Element 1, Nikolai endangered the safety of another human being. That's obvious. Endangered the safety of another by criminally reckless conduct. The jury instructions define criminally reckless conduct, creating a risk of death or great bodily harm. It's unreasonable and substantial. He was aware of the risk. Again, obvious when he's stabbing people. When you talk about reckless conduct, let's say you believe his testimony that he just thought anyone touching him, anyone close to him was attacking him and just stabbing him. That's reckless. That's criminally reckless conduct. That's utter disregard for human life. What other clues are there to utter disregard? He just walks away. He just walks away. He doesn't call 911. He just sits on his tube as other people are helping the victims. And he tubes down the river. Your jury instructions talk about the question, the special question, yes or no. Did he commit these crimes while possessing a dangerous weapon, the pocket knife? There's nothing inherently wrong with carrying a pocket knife. A lot of people carry pocket knives. Totally fine to carry it as a tool, totally fine to carry it for self-defense, totally fine to carry any legal weapon, firearm, knife, if it's used legally. Nikolai he was not justified in self-defense when he attacked these people. So we ask that you answer yes on that question. In the end, what is beyond clear, Nikolai knew this was not self-defense. All of his actions, from the minute the stabbings are done, from the second the stabbings are done, he knew it. It's obvious. His actions were horrific. They were senseless. He killed Isaac Schumann, stabbed him directly in the heart, disemboweled AJ, stabbed Tony who's trying to break up a fight, Riley who's just standing there, and then walks up to Dante. That walking up to Dante, stabbing him when he's got clear paths to retreat, that destroys any argument that this was self-defense. He was angry. There's no rational reason Nikolai, his group's over here, would walk this way towards the group of people to stab Dante. Senseless and horrific acts. The state asks you to find Nikolai guilty of all charges. Thank you.
I wasn't a big fan of the.
Thank you. We will take a 10-minute recess. We'll be reconvening at 11:05. Please take the jury out.
All right, for the jury.
Not a huge fan of the delivery from the state there on that one. I think he hit all the pertinent points, did get into the elements. When he's talking about the elements of the case, I don't like when the lawyer's like, well, there's this element, that one's obvious. There's this element, that one's obvious. Don't say that. Spell it out for the jury. Spell it out for the jury. We can see this because of this action. This was proved when we brought this testimony. But just saying, well, yeah, you've got all these elements. That's obvious, check. Yeah, this one, let me explain that one. Because it makes it seem like the that the other ones aren't obvious, right? It makes it seem like, well, we nailed these ones, but we're a little bit flimsy on these ones. Let me try to help you through it. It seems to lack. Just be deliberate. Bring out the evidence and say, this is why we proved this. To prove this element, we called this witness. We can see that the intent was there because we see this in the video. I think that's going to be a better explanation for the jury. The jury has enough worry on their plate with the 200 pages of instructions the judge read to them this morning, which is just, they've got a lot to handle. And I think really the first question after they get a juror is like, how many think this was self-defense? They've got to do a poll. And maybe if they all get to self-defense or not, then they could work on something else. But if they have people who are 100% saying this was self-defense and somebody else saying he crossed the line, he didn't have the right to use that knife, we might see a record hung jury as far as the time frame, because there's the middle ground between self-defense and guilty of second degree. That's a huge step. It's a huge step. It's obvious it's not a good argument. I agree. It lacks some passion. The structure was questionable. I think this is something that you could walk through sequentially in time, and it would have made sense to the jury. We've seen it over and over. That's how they presented a lot of the case, and then to have the finish just like, well, let me start with this portion, and now let's go back what happened over here. And we saw that. And you remember what happened over here? We're hop, skipping, and jumping around the case, and it just leaves gaps and questions in the minds of the jurors, which makes them rely on their notes. And in a closing, you want to button this up tight, right? You want this to be delivered in a signed, sealed package. They can just open, stamp the check mark that got the little yellow arrow saying "sign here," and deliver your verdict. And I don't think they did that as a state. I think they've got another chance at it because they get 2 bites of the apple, right? The state goes first and the state goes second, I believe. The first and last. The second is going to be a defense. So they get another chance at it. I don't know if they get a different person on the second half, but we'll see. We'll see. Some parts that I think he did well. Man, bringing up that we're not a stand your ground state. Why don't you spend more time on that? Everybody knows stand your ground. Everyone understands castle doctrine. We hear that all the time in the news. But how many people understand what that means if you're in a stand your ground state or if you're not in a stand your ground state? Explain why that the jury can consider the fact that he had the opportunity to retreat and didn't. Explain why that's significant and what that means in their discussion. He seems like he skipped over some things that he could have spent a little more time on. Maybe the state was forced by all the family members to bring this case. I think there's enough question. I mean, look at us as a group. We're what, 60-40 split on this? Okay, it's pretty well split. I think there's enough question here, especially with the behavior of Mr. Mew afterwards, that this is like, yeah, let's bring charges. Let's bring charges. They don't only pick the charges that they 100% know they can prove because they've got video evidence of the entire crime and the suspect admitting to it on camera. It would be nice if all the trials had that. It's just not there. Paul Young's gifted a membership. Thank you, Paul. Thank you very much for your generosity. Appreciate that. That one went to me, Emily Looney. Congratulations, Emily. Not completely sold on self-defense, Angela. You would have given a better closing to the state. I'm not going to say that, Angie. First of all, I'm not a lawyer, so it makes it a little bit harder for me to do a closing. but no, I think that the state has a tough road here because they're the ones that asked for the lesser includeds. The jury doesn't know who asked for them, right? They just know there are lesser includeds. But the state asked for lesser includeds, and we know that generally we can view that as like, look, we're not sure, okay? We're not confident we're going to get that charge as charged. We're not sure we proved it. Okay, I could look at that, and that's the impression I get from the state. But they've got so many lesser includeds, and the guidelines for what the jury can consider on whether or not Mr. Mew is guilty on that lesser included is so different from the original charge. They're like two different cases nearly. On the first charge, you can't consider whether or not the level of force was necessary, but on the second one, you can if it was a reasonable amount of force, and it gets a little convoluted, and it made his closing be a little weak because he now had to give a closing that addresses both angles, right? He doesn't want to say, hey, look, at least get him for second, right? Because you don't want to sell yourself short on your closing. What if the jury was with you all along? But if they're not, he's got to give them that little guidance. And so that made him jump around a little bit. And I think that was a cake of their own making, because they chose to have those lesser includeds included. State chose that, defense opposed the lesser includeds. But either side can ask. Okay, I wouldn't have charged in the first place because the state wanted them. They're not confident in their case. So he left twice and came back twice. Why not just stay gone? It's a tough question. I hear you. Why didn't he just walk away? The jury can consider that in part of their deliberations. Why didn't he just walk away? I think you'll hear. I think we heard, and this explains why we heard it so much during the trial. Why so many times witnesses were asked or were presented from the defense, usually with you guys surrounded him, right? You guys surrounded him. Who's in back of him? Whose position? Let's draw the picture. And where was Mr. Mew at that time? So you're in front, he's in back, he's on the side, so he's surrounded, right? We heard that word surround over and over and over. The state wants that word surround there because that eliminates the possibility of retreat, right? If any way is trouble, now you can stand and fight. But obviously they didn't get it, and the state fought very hard against that. Every time they're saying surrounded, there would be like, no. That's not the word he said. He didn't say he was surrounded. He said we were approached, or we were near. They said we were in a half circle, but it wasn't all the way around. Mary Tedeschi, thank you for the super chat. I appreciate that. Thanks for the super sticker. That is awesome. I appreciate you. Maybe the state read the chats. Everyone's divided on this one. I would be stupid of the state not to read and follow some of the live streams and the communities that are commenting on this. It's like free advice on how you're doing mid-trial. So many times when we watch, say like in the Thurston Washington trials, we hear the judge say, now the prosecutor and the defense attorneys, this is their first trial. I don't know why that's everyone's first trial up there. They'd like the jury to stick around and answer some questions. So if you guys can stick around, they've got some questions. What resonated, what didn't, what did you wish we did more of or did less of? And here in this trial, it's televised. We've got live audiences that are commenting on it, and the jury, you can't ask them in the middle of the trial, but you sure can get a public perception on some things, and basically you can test your closing in trial in some ways a little bit with what evidence is good. Hey, Mrs. R.A., how are you doing? Oh, you want to talk? Here we go.
He ignored my comment in chat, and so I'm just coming in here to basically say what my comment was. If I understand properly, they're waiting and they're about to have defense closing. Is that right?
Yes, we've heard closing.
Okay, so here's my point: that if they happen to be listening, what do you think is most important for defense to get in on their closing?
I think the defense has strong language in the law in Wisconsin for self-defense. The way the law is written and the way the testimony went for defense, I think they have a good argument, especially for how Mr. Mew testified, that he was acting in self-defense. So if they can read that law, which is a given, right? This is fact. This is where we stand. This is truth. And then show how Mr. Mew followed that law or fit perfectly within the parameters of that self-defense law, I think that will resonate. I think that will. They have to admit, they have to acknowledge that he lied. And I mean, that's hanging out there. And we'd say, look, we know he lied, but they need to have a reason. Mr. Mew on the stand, he said, I was in shock. I don't remember that. Do we believe him? No. Mrs. R.A. says no. A lot of people say no, they don't believe him, but that's not the offense he was charged with. Okay, he was not charged with lying to an officer. Can we take that as maybe evidence of guilt, consciousness of guilt? yes, under some charges, I think if you get there, but you have to first get past the self-defense. If you are with him on self-defense, and I think the easiest thing the defense could do is the thing they're not allowed to do, which is say, put yourself in his shoes. Okay? If they do that, you're going to hear an objection. Jurors, put yourself in his shoes. Okay, because we have a lot of jurors who are at or over his age. How would you feel if you had these kids yelling this at you when you were doing nothing wrong, walking there trying to help look for a phone? You can't do this. So I think this is an impermissible argument. But if they can get as close as they can as to so the jurors start thinking that. It's like, I think the way they can do it is talk about the reasonable person. Jurors, you're called as reasonable people. Okay, what would a reasonable person such as yourself do in this situation? Would you be scared for your safety? If you'd been punched, knocked down, held down in the water, or people surrounding you yelling, the conversation elevated as it is, that might be their most effective thing. They have to address the elephant in the room, which is the lying, and they have to do it effectively to the juror's satisfaction, so they can say, "Look, I can accept that explanation as to why Mr. Mew lied. I'd lied. But you've got to be able to convince them of that. So how do you convince somebody that lying was a good thing? I don't know. I don't know.
Pop over there so we can both talk. Can you plug it in? Okay. So, my headphones aren't plugged in either. Okay, nothing's plugged in. So here's my thing with the lying, and I do find that this is quite ironic that I feel this way on this case, because on at least one other case for me, when I discovered that the guy was lying, I was like, well, that's case closed. It's over. With Murdoch, I was like, well, that's the lie. And that's the nail that sealed the coffin. That's the end. I understand now because you're willing to lie about that one thing. It made it very clear to me. Whereas I look at this, I'm like, yeah, he's lying. Clearly he's lying. I don't think it has any bearing on the case. He's lying because he's scared of the cops. Well, even if he's not, I feel like if I'm defense right now, who cares? Who cares why he lied? I get that that's a bad thing and you shouldn't lie, but it has no bearing on that moment. That moment is the only thing that mattered. Was he feeling threatened? Was he defending himself? I think you prove that and it's over. And yeah, you probably do have to address he's lying because he did. I think he lied through his teeth. I think he lied because he was scared. I think he lied because he anticipated some version of his current reality and he didn't want to face that, and I can't blame him. Or are they coming back? Okay.
Thank you, Mrs.
Angle
Arden.
that toward the well.
Wow. Somebody is sandpaper on the microphone. Apologize for that. Thank you, Mrs. Ari, for your thoughts on that one. Linda M., congratulations on the 2 months, as well as Drew at IRL. I think I missed you there.
Please be seated.
Anna, Anointment Park.
All right, we are back in the presence of the jury with the attorneys and Mr. Mew. Mr. Truffesy.
More thoughts later.
Please, the court, counsel. So, ladies and gentlemen, in his opening statement, Attorney Nelson said to you, one of the things you're going to have to determine is what happened on July 30th, 2022. Well, what happened on July 30th, 2022 is a group of drunk teenagers led by the ringleader, Juwan Cockfield, saw an opportunity to torment a man who was by himself. They taunted him. They called him names like raper and pedophile and predator. They did this for no legitimate purpose. When they did this, they're yelling and carrying on. It attracted the attention of another group, right? Led by Madison Cohen and Dante Carlson. 6 drunk teenagers quickly turned into 13. 13 against 1. They got in his face. They screamed at him. They called him names. They swore at him. They put their hands on him. And the group of 6, they became brave. The group of 6 became brave to the point that they circle him and start taunting him. They do this to a man who has done nothing, absolutely nothing to them. Then, when that man, Mr. Mew, tries to create some space between him and Madison Cohen, they pounce. They punch him. They push him. They slap him. They hit him again. They choke him from all directions. And Nick Mew acts in self-defense. That's what happened on July 30th, 2022. I just want to give you guys a little bit of an indication as to kind of where I'm going to go, and more importantly, what I think you need to think about when you are back there thinking about the evidence, okay? First is the law. 1, there is no duty to retreat, period. That is the only requirement. In this state, bullies like Madison Cohen don't get to tell us where to go. Bullies like Madison Cohen don't get to get in our face and require that we leave. That's not a requirement here. Keep that in mind. 2, subjective beliefs, okay? When you're listening to or contemplating the evidence and replaying it in your mind, you are to do that and consider the beliefs, not the actions, but the beliefs of Mr. Mew. And when you do that, you are to do that from his perspective at the time that the events were occurring. So while we have a video, that video is from the perspective of Joanne Cockfield. The video perspective that the jury is required to consider it is as Nick Mew is holding the camera. I'm going to address this a little bit later, but the idea of provocation. Whether or not Nick intentionally caused harm to Madison Cohen. That is something that you should consider when you're considering provocation. And the other main one I want to talk about is what it means, because it's different here, beyond a reasonable doubt. So normally, beyond a reasonable doubt is this hurdle, and the state has to jump that hurdle in order to prove a case. It's a little bit different here. Okay? Because in this case, self-defense has been alleged. Remember when you're back there, Nick Mew doesn't have to prove he acted in self-defense. They have to prove beyond a reasonable doubt that he didn't act in self-defense. They have to prove that his beliefs were unreasonable. Okay? So the way that I look at this video, the main video of Joanne Cockfield, we've all seen the 9-second video where he's screaming at Mr. Mew, calling him a raper. I'm not talking about that. I'm talking about the video that you've seen probably more than you want to. But I'm breaking that up into really 3 parts, okay? 0 to 149 is the first part, all right? Before anything actually happens in terms of the attack. And what is in dispute in that first minute and 49 seconds? I think two things were raised in the case that were in dispute. And that is, first, whether or not these drunk teens were actually afraid of Mr. Mew, right? I think to a person, they testified, yeah, we were really concerned about Mr. Mew. And you get to use your everyday experiences in life when you decide what to believe. Does that look to you like teenagers who are afraid of that person? Is that what that looks like to you? Does this photo of drunk teenagers taunting him, does that make you believe in your experiences in life that they're afraid of him? Or is this what drunk teenagers who are terrified, is that what they look like? Does that make sense to you? Because you heard this. As the numbers rose, as the number of people grew, their fear, it decreased. And you've heard Mr. Anderson say over and over again, all Nick Mew had to do was walk away. Well, you heard from each one of those tubers, those drunk teenagers, we could have passed. When he walked over by Madison Cohen, we could have passed. And you heard Owen Pelican. I didn't want to pass. I wanted to see how this was going to play out. Why? Because Joanne Packfield was recording this entire incident. They wanted to see what was going to happen. They're not afraid. They want to see how this is going to play out. And Joanne Packfield said it best of all. It's for the culture. He wanted to put it on the internet so other people could see. And when you're using your everyday experiences in life, ask yourself this. Do people who are afraid of other people, do they walk up on them? Is that what people do when you're afraid of someone? Or do you try to get away from them? If you're afraid of someone, do you taunt them? Do you call them names? Do you circle around them? Those are questions that you all can answer. Or an alternative hypothesis to them being terrified is, do they do those things because they're drunk teenagers and what they want to do is make a video and put it on the internet? Which one of those two things, based on the evidence that you've seen, which one of those things makes more sense to you? The second thing that I think is in dispute, or was at least raised in the first minute and 49 seconds of that video, is whether or not Nick Mew's looking for little girls. Now, Mr. Anderson gets up here and says, no, he wasn't looking for little girls. But he also says, the boys didn't invent that. No, they pretty much invented that. And why do we, or how do we know that? So that's not on video anywhere, right? They don't mention it. They don't say anything about Nick Mew telling them that, right? Every one of them who speaks to the police provides a statement about what happened. Zero mention to the police that he said he was looking for little girls. This gentleman over here, Investigator Schultz, I think he said that he was a sensitive crimes investigator. He saw some of this stuff come across his desk, and that would have interested him. Investigator didn't testify. Said he would have mentioned, if any of these kids would have mentioned little girls, I would have taken note of that. So, What's the alternative?
Is he going to say
Why
they
did they say
collaborated and lied?
I would submit to you that what kind of person does what these kids did to him, and what would they look like as people if all they did was pick a guy out and start to torment him? What do we think of people who do that? What do we think of people who call grown men rapers and pedophiles and predators for kicks? What do we think of those people? They had to come in and say that. Because if they don't, we know what we think of them. That's the reason they came in, and they said this to you guys under oath. They got on that witness stand and swore to tell the truth, and they told you that he said he was looking for little girls. Well, the cops got up under oath and told you, nah, they never mentioned that to me. What are the odds? What are the odds that actually happened and nobody mentions it to the police? What are the odds? Two other little points on that. In your everyday experiences in life, would you expect a man that you never met to walk up to you and say, if you ask him, how's your day? What are you doing? Oh, I'm looking for little girls. Would you expect someone to actually do that? Does that make any sense to you? He's with his wife. He has lunch with his wife and his friends. In order to believe what these drunk teenagers are saying, you have to believe that he has lunch with his wife, he's with his friends, they're having a fine time. Ariel loses his phone, and Nick goes, this is my chance. My wife's right over there, but this is my chance to go look for little girls. And I'm gonna tell a bunch of drunk teenagers I've never met before, that's what I'm doing. Tell me that makes sense to you. Because you get to judge the credibility of what people have said to you, okay? But I want to talk about what we know in that first minute and 49 seconds of the video. What do we know? We know, based on the evidence, that Nick's looking for a phone. We know that. Ariel said that, Nick said that. They find Ariel's phone in the river, so we know that. We know that Nick comes up to the teenager's tubes, and we know that Cockfield's looking for a phone, and Cockfield's holding a phone. Joanne Cockfield's holding a phone. We know that Nick Mew walks away from them as he passes them. We know that. We know, right, that the drunk teenagers move toward him and start confronting him. We know that. We also know that Nick sees what he believes to be a reasonable, rational adult. So he heads over there to talk to her. And what we know is you can see his thumb, he's motioning back, trying to explain what happened. And we know that Madison Cohen, who knows nothing about what happened, zero, starts screaming at him to leave. We know that Madison Cohen feels comfortable enough to put her hands on him for the first time and move him because, well, she's queen of the river and she decides where people go. So she's moving him. We know that. We know that Nick is uncomfortable, so he waits for his group to come over because the state can say whatever they want. He's by himself. So we know Nick does that. We know that when Nick waves to his group, so does Madison Cohen. But there's one big difference here. Her group shows up, and they show up in numbers. We know that the group of teens are brave, and as this is going on, they start taunting this man who's done nothing to them. We know that. We know that Riley Madison comes over, and now she thinks it's necessary because she's been anointed something in the river, and she gets to tell him where to go. So we know that she puts her hands on him.
We have Lady of the Lake and Queen of the River.
That Nick's uncomfortable enough that he waves the group over a second time, trying to get someone to come to his aid. We know that. We know that Madison Cohen pushes him, puts her hands on him again. He tells her not to touch him, but she does it anyway. We know at that point it's 13 against 1. The other thing that we know, because we heard it, was someone in the group, the brave group of 6, tells Nick Mew, you got 10 seconds. In your everyday experiences in life, when someone tells you that you have 10 seconds, what normally comes after that? If we have children, I'm going to count to 3. You got 10 seconds to do this. Nothing's good is coming after that. It's reasonable in our experiences as adults to take that as a threat, right? And if you think about it, they all blamed. They didn't know it, but the guy holding the bag is Isaac. We know it's not Joanne Cockfield, and everybody else denied it. So who's left? Their buddy Isaac. They all blame, without saying his name. They're saying, wasn't me, wasn't me, wasn't me. Well, they're saying it's the one person who isn't here. Right? That's what we know. We know everything here I just told you is what we know in the first minute and 49 seconds. And why does that matter? What does...
Judge, I can't see the exhibits and I'm doing rebuttals.
And step up and move over to the side.
Judge, like, move your butt. Judge, I can't see. Move.
What does that matter? Why does this matter? Because one of the things you have to consider when you consider self-defense is Nick Mew's reasonable belief that there is going to be an imminent interference with his person. And when you add all of these things together, he has to subjectively believe that. As a jury, as you sit here today, we don't get to look at it and say, what would an objective, reasonable person do? Does Nick feel that way? Does Nick feel, with all of these things listed here, that there is an imminent unlawful interference with his person? And I would submit to you, he does. He told you he did. Right? We're going to see the video one time, promise, broken up into those parts.
You didn't come here to spell, guys. Yep, caught a typo on the chart. Okay, you're going to hear some stuff here. Just heads up.
What is he on? Whoa! 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 Where's the way? Oh, God! What are you talking about? What the hell are you What?
Get away from us!
What?
What are you doing?
What's going on with y'all homie? He's on camera.
Guys, let's go.
Scripted. He's on 14. Yo, the new iPhone got that good quality. What do you say? Yeah, what the hell? Who is this? Yes. Further culture. Further culture. Who is that? Further culture. Who is that? Who the hell is this?
Go! Doesn't matter.
He said he was looking for a little girl.
You're looking for a little girl?
Yeah.
That's exactly what he said.
Weirded us out. I even have that part on camera. Did I?
Some young ass kid.
What the hell is this guy's problem, bro? We're trying to have fun. He's gonna close you. He's gonna claim you. We don't want this one.
The second part of the video that I think is important, and Attorney Anderson's talked a little bit about it, is the 1 second that we don't get to see, right? The 1 second where the state is insinuating and is claiming that Madison Cohen was punched, and where Nick Mew has testified that he raises his arm to get her out of his space. So those are the two possibilities as to what happened in the video that you don't see. And I am, once again, asking that you use your everyday experiences in life when you make this determination, okay? And I understand that people in stressful situations don't get everything perfect. I get that. I'm not holding anybody to this exact standard. But what have we heard in order to prove beyond a reasonable doubt that this happened? Well, you heard A.J. Martin say that he grabbed her by the back of the hair and was slugging her from behind. Okay? No one else says that. You hear Alex Vang say he slapped her with a right hand in the face. Then I say, Mr. Vang, how can that happen? He's got a knife in his hand. And he says, you're right, that can't happen. He punched her. You hear Juwan Cockfield, who's not looking at it, he's holding his camera in another direction, says he threw a hook at her. I saw that. Right? Madison Cohen says, she said on direct examination, he hit me with a left hand to the left side of my face. And it said that. Then when I asked her questions and I said, can you explain how that's humanly possible? And her response was, you're right. I get lefts and rights wrong. He hit me on the other side. Okay. But the state says she had a heartbeat in her cheek. She should remember what side of her cheek the heartbeat was in. She doesn't get that right. But how about the things when you use your everyday experiences in life that the state, they didn't talk about when he was up here talking about her injuries. He talks about her falling back and people seeing things. Okay, people can be wrong. How about things that make sense, though? We know that she's wearing sunglasses, right? We know that. Her sunglasses are not broken. She doesn't have a mark on her face from being cut by sunglasses. None of that. Is that what would happen if a 250-pound man squared up on a woman and threw a hook to her face, she doesn't have redness on her face. She doesn't have swelling on her face. She doesn't have puffiness, a bruise, or a mark. How do we know that? Investigator Schultz told us, I saw her shortly thereafter, and she didn't have a mark on her. He says, if I would have seen a mark, I would have taken a photograph of that mark. Makes sense, right? She doesn't drop her drink. She doesn't drop her vape. Her cell phone doesn't leave her bathing suit. Is that what happens when a 250-pound man squares up on a woman? She doesn't drop a thing, and she doesn't have a mark. Does that make sense to you all? Or does it make more sense that Nick Mew pushes her out of his space? Attorney Anderson said she's not in his face. Well, most of her friends said, no, she was. She was in his face. She was in his face. She was in his space. Right? If he makes this motion, she's not going to have broken sunglasses. She's not going to have a mark on her face. She's not going to have redness, puffiness, swelling, a bruise. She's not going to drop her drink because he doesn't hit her. Which one of those two things in your everyday experiences in life makes more sense? You get to decide that. And I want you to think about this. She knows the seriousness of the case. She tells the police she takes a photograph or photographs. Then she claims to have deleted them in a homicide case. Then the police say, that's okay. That happens. You give us your phone, we can get the pictures. Right? Wrong. They do a Cellbrite downloaded extraction of her phone. Investigator Schultz doesn't do it, but he reviews it and says, there's no deleted photos that I saw in there. He even goes so far as to reach out to Madison Cohen's mother, because maybe she either took the photos or were sent the photos. No, not there either. You get to judge the credibility of people and whether or not that makes any sense. That is not provocation. And just briefly on retreat and provocation. I told you when I started, there is no duty to retreat. And that is true. That's the first sentence in the retreat instruction. If you want to, it says you may consider whether or not when he was retreating, or if he had to retreat, whether the defendant reasonably believed the amount of force used was necessary to terminate the interference. You may consider whether he had the opportunity to retreat. Okay? Now you don't have to, but when it starts, when it matters, is when he's using the force. And when he's doing that, he's surrounded. He told you he was surrounded. I asked Lieutenant Hart, do you have any information that would be contrary to Nick Mew's belief or statement that he was surrounded? She said, no, I don't. Where's he gonna go? So he doesn't have to go anywhere. We don't let people dictate what we do, and the loudest voice in the room doesn't have to win. Madison Cohen doesn't get to make these decisions for people. He doesn't have to leave. The drunk teenagers don't have to leave either. They told you they could have left, but they wanted to see the show. He doesn't have to go, and there's nowhere to go. That should be the beginning, middle, and end of that evaluation on retreat. Same analysis, same result on provocation, okay? You have to find that Nick Mew committed an unlawful conduct against Madison Cohen to provoke this attack. He wanted her to get out of his personal space. The bully in the room doesn't get to yell at you and tell you to leave, and then when you don't leave, doesn't get to get in your personal space because you are not leaving. That's not how this works. The last part of the video is the 150 to 205 mark, okay? Now, you heard yesterday, the state wants to break this video, this last 15 seconds or so, down into stills. 1/24th of a second. No one lives their life in 1/24th of a second. And you're not supposed to in this case, because you're supposed to look at this case through the eyes of Nick Mew. And if you've watched that video, the first time I saw it, I didn't see what happened. I didn't see him pull a knife. I didn't see some of these people getting injured because it's moving like this. When you break it down to 1/24th of a second, it's just not how we live our lives. You have to look at those 14 seconds through Nick Mew's eyes as he was standing there in the river. And remember, he told you yesterday that he believed that he was going to die, but he doesn't have to believe that. He just has to believe that he's going to suffer serious bodily injury. That's what he has to believe, okay? And before I start this video, I'm going to ask you this again. What do we know in those last 15 seconds? We know that Anthony and Dante Carlson were asked by their dad to go over there. Why? To help him. Quentin Carlson testified that he was concerned that Nick Mew was going to get the brakes beat off of him. So Quentin Carlson wanted his boys to go assist. I would submit to you that Quentin Carlson was concerned that Nick Mew was going to suffer serious bodily injury if someone didn't help him. Alex Vang told you Mew's getting his butt kicked when this is going on. And Owen Peliquin said those guys got on his ass. Right? Anthony Carlson is yelling, stop, stop, stop. He's not yelling it to Nick Mew. Nick Mew's tail down in the water. Presumably, he's telling it to the people who are beating him. Right? That's what we know. Now, Juwan Cockfield found that to be funny for quite some time. You can hear him cackling on how he thinks it's funny that Mew's getting punched in the face and knocked in the face, slapped, okay? But what we know from that video is a 250-pound man. 250-pound man has been knocked clean off his feet backwards into the water by getting punched in the jaw. That's what we know. We know that in 1 second, Dante Carlson, who throws that punch, runs around to the other side of Nick Mew while he's still on his back, kind of on his lower, on his butt, kind of on his lower back, and he cracks him across the face. We know that. That's not in dispute. We know that AJ Martin, who says he's the peacekeeper, that's what he said. He runs up from behind and shoves Nick Mew while Dante Carlson comes in for thirds and smacks Nick Mew in the face again. I would submit to you at this point, it's coming from all sides and from multiple people. And this man who had heart surgery is terrified as to what's going on. We know, well, let me just remind you of this. At this point, after he's been punched, slapped, pushed, slapped, he hasn't stabbed anyone. Right? And if you listened closely to what AJ Martin said in his testimony,
I thought he'd already stabbed the girl at that point.
when he was shown the picture of him making contact with Mr. Mew before Mr. Mew stabbed him, he said, he got me before I got him, I guess. What does that tell you about what AJ Martin's intention is? He's back in the water now for a third time after getting pushed down by AJ Martin. And what do we see next? That's Anthony Carlson. He walks right by me. Mew doesn't do a thing to him. Mr. Mew doesn't do a thing to Anthony Carlson as he walks by. You will then see, and what we know is Anthony Carlson comes up from behind him, appears to be yelling at him and putting his hands on him. So now Mew has been touched at that point, punched, pushed from behind and slapped. And now Anthony Carlson comes up to him. We know that. And then we know 1 second later that Isaac Schumann comes up to him. You guys get to make the decision on whether or not he's choking him around the neck. You get to make that decision. I'm not telling you what that is. You get to decide if that looks like a choke to you or not. So at that point, 4 people have attacked Nick Mew. And why does it matter? Why does any of that matter? Because if you find the following, Nick Mew is not guilty of all the charges, okay? If you find that Nick Mew believed that there was an imminent unlawful interference with his person, if you believe that he believed that was coming, the 19 or 18 reasons that I put up there supports that, and he told you that. And that's his subjective beliefs, okay? If he believed the amount of force that he used was necessary to terminate that interference, okay? So if he believed that he did what he had to do, right? I would submit to you there's only 2 answers to that. Only 2 possible answers. He either did what he had to do to survive, or this man who, you watch the video, who's never got a speeding ticket, who decides to go out with his wife that day, who's floating down the river and having lunch, decides, you know what, today's the day I'm gonna start stabbing people. I'm gonna leave my group, I'm gonna go over and I'm gonna start stabbing people. Mr. Anderson says he snapped If he was in fear, he would have left. I think anybody would dispute that he was in fear. So when you're determining whether or not what he did, if he believed that he had to do that to terminate that interference, I would submit to you, why else would he do it? He either believed that or he just lost his mind. Right? This 52-year-old engineer who's married just lost his mind that day. Those are the two options I think that you have on that. And the final thing that you need to decide is whether or not his beliefs were reasonable. And the standard is, would a person of ordinary intelligence and prudence would have believed standing in his shoes at that moment. Okay? Quentin Carlson is about his age. And Quentin Carlson is concerned enough for his safety that he sent his boys over. Quentin Carlson tells the police that after his boys have been injured. He tells the police, I get it, they're injured. I sent them over there because I was concerned for the old guy. Brandy Hart. Did you watch that video yesterday? There's a point in that video.
One of the jurors like, no, I slept through.
Where Nick Mew puts his hand in his head and says something like, my life is over. And Brandy Hart says, I don't know about that. They're self-defense. She says, I don't know what I would have done. But I can tell you I would have been scared shitless. She's been a police officer for 25 years. And that is her response. State never followed up with her on anything after that. That was her statement to the police. Or that was her statement on the tape. And as I mentioned, Alex Vang and Owen Peloquin say he's getting his butt kicked. They're all over him. Are those reasonable people? You get to decide what a reasonable person would do in that situation. But I would submit to you, you've got something to work with. You've got something to work with. Briefly on the charges, okay? Before you even get to self-defense, you get to intent. You have to find intent on the homicide charges initially for Isaac Schumann, and you have to find them for the others involved, okay? And the question on intent is mental purpose. Can you watch that video and say that Nick Mew's mental purpose is to kill Isaac Schumann? Or is his mental purpose to get another person off of him? You get to decide that. Okay? Under those circumstances, you heard everybody say, anybody who never touched him, he never touched. Right? People were like, I didn't want to get near him. They didn't touch him. He didn't touch them. He didn't say anything. You get to consider all the facts and circumstances. He didn't say anything to Isaac. Right? Isaac grabs him by the throat and he stabs him one time. Is that an intent? Is that his intention to kill Isaac Schumann? And when you started this case, you heard that was the charge. Well, those charges have changed. Now you get to consider all other kinds of charges, with all other kinds of mental states too, right? Maybe it was intentional. Well, maybe not. Maybe it was reckless. Pick a theory. Don't let them just throw things against the wall and hope that you guys let something stick.
This is a gray area.
They're telling you they thought it was intentional. Now it might not be. Now it might be reckless. They don't have it. Nick Mew wanted to get Isaac Schumann away from him. He didn't chase Isaac Schumann down. He didn't move toward Isaac Schumann. Isaac Schumann moved toward him. And on the attempted homicides, read the instruction on attempt, you guys. In order to convict someone of an attempted homicide, the state must prove to you beyond a reasonable doubt that demonstrates unequivocally that Nick wanted to kill these people and would have, except for the intervention of another person or some other extraneous factor, okay? And unequivocally means there can be no other inference which can reasonably be drawn. No other inference. And an extraneous factor is something outside the control of Nick. You heard DA Anderson say, but for medical intervention, some of these people would have died. Well, AJ Martin would have. Dante Carlson had a hernia. He repaired a hernia. Sorry, medical intervention doesn't prevent him. He's not going to die from that. Anthony Carlson gets 2 stitches. He's certainly not going to die from that. And Riley Madison could have got an infection, they said. I understand that. But if he wanted to kill them, why didn't he? If you believe Attorney Anderson, he's alone with Dante Carlson. Why does he stab him one time? He wants to kill him. Why doesn't he smash him up? He wants what he wanted all along, to get away from these people. He's leaving, and Dante Carlson, who has beaten him up, has hit him in the face repeatedly, confronts him again. What does he think? What does Nick Mew believe is about to happen? You don't have to let somebody beat you before you respond. Doesn't that make sense? And because they don't have the attempts here, because there was no outside extraneous factor, they also say, might not be attempts, take a chance on reckless. How about that? Again, not really a theory, but you get to make that decision. I'm going to comment on the video because I think it's appropriate that was played, the interview with Nick and Brandy Hart. He lies about the knife. He lies about the knife. What Lieutenant Hart said is he's never wavered on is that this was self-defense. That he was fearful and that he was being attacked. Okay? That he's never wavered on it. He said it over 20 times in the interview, and it's the first words out of his mouth when he's interviewed by Lieutenant Hart. Some people get some facts wrong, some people lie about stuff. He's not telling you the truth about the knife. But does it change one thing that you saw on that video? That's the reason we want there to be a video. Is so you're not taking the word of 13 people who don't get it right. That video is not subject to change. Attorney Anderson's right. It is what it is, right? What has persevered through this case is Nick Mew's fear, how he felt, the shock. You heard people testify about that, the whiteness, the wide eyes, the ghost-looking color of his skin, that has persevered through this case. He lied about the knife. Doesn't change one thing that's on that video. You should feel sympathy for Isaac Schumann's family. I have a 19-year-old son. He would be in Isaac Schumann's grade right now. Everyone feels sympathy for Isaac Schumann's family. I'm sure he was a wonderful kid. And I know that his parents love him. But you don't get to decide this case based on sympathy. The judge tells you that. You decide this case based on facts and evidence. That's what you are required to do. And put most succinctly in terms of the burden of proof and what the state has to do is they have to prove to you beyond a reasonable doubt it's not self-defense. And what does reasonable doubt mean? Well, the judge read it to you. You'll get to hear about it again. But it's a doubt that would cause a person of ordinary prudence to pause or hesitate when deciding the most important affairs of life. And I would submit to you the most important affairs of your collective lives are your health, your family's health, loved one's health. When you're thinking about that and you have to make hard decisions on those things, if there is a pause or hesitation about what you need to do because you're getting information from various places, you say, I need a break, I need to figure this out.
I'll have a pull up in just a moment.
That's reasonable doubt. Okay. It is a doubt for which a reason can be given. That reason is self-defense. And I just want you guys to know this. When you go back there and you have those verdict forms, if you believe it's self-defense, he's not guilty. If you believe it's probably self-defense, he's not guilty. If you believe it's possibly self-defense, he's not guilty. If you're like, it likely is, I don't know, not guilty. If you believe it might not be, not guilty. If you believe it's probably not self-defense, not guilty.
That's
all of those considerations that you would have require a verdict of not guilty. Because the state has to prove to you beyond a reasonable doubt that it wasn't self-defense. So, as I go to sit down, we, Attorney Nelson, Nick, you and I appreciate all of your time. The time that you've taken away from your families and friends to do this. The attentiveness that you've given us. And I think it's time for people to go home when you're done. And what we're asking that you do is that you send Nick Mew home. That you find him not guilty on all of the charges. Thank you.
Okay, we are putting a poll
While we
up
swap
right
people
now.
out, if you'd like to stand and stretch for a moment, you may do so. And then we'll hear a brief rebuttal from Mr. Smithstone.
Brief, as the judge says, brief. Poll is up right now. I'm not putting hung jury on here because I'm asking what you would vote for. What you would vote for on the poll. The poll says, what verdict would you vote for? Not guilty, meaning self-defense, guilty of first degree, guilty of second degree, or guilty of reckless endangerment. Where would you fall on this? Doing a little rearranging here. I think the rebuttal.
You just heard Mr. Prophecy say his entire defense is based on what Nick Mew told you
I wrecked the
during
spell.
his
I'm sorry.
testimony was thoughts in his head, the beliefs in his head. What do we know about Nick Mew? We know he's smart, speaks multiple languages.
Oh, they changed out.
Has a couple of degrees, one's in math. He's a calculating person. He's a cunning person. He's a skilled and prolific liar. We know that because every word that came out of his mouth practically, since he started walking away from this group, was a lie, including to his best friend, who he said they took my knife while the knife is still on him. The things he said to Sheriff Knudsen, where he pretended to not know what was going on. And then everything he said to Investigator Hart, Lieutenant Hart. He is skillful at crafting a story that matches what he needs to say to avoid the consequences for his actions. We all know that, it's undisputed. He told you himself, he's a liar, all right? He did not just not lie about the knife. He lied about all kinds of crazy things, bizarre things. Why would he say that these boys pulled his pants down? What a bizarre lie to make up, right? Why would he say that two boys pulled knives on him? He's got to say that because he knows what he did wasn't justified. He thinks to himself, if I say one boy pulled a knife, that would be good, but if it's two, that would be better. So he crafts this elaborate story. His entire defense rests on you believing what he said on the stand yesterday. His testimony was a disaster. He got caught in several lies on the stand. He changed his answers a couple of times when he realized that what he said wasn't helpful to his defense, right? He consistently remembered details from July 30th, 2022 that benefits his defense, but doesn't remember anything about what he did, any of the facts, any of the stories that he told Lieutenant Hart. How is that possible that he can only remember the facts, the beliefs he had that assist his defense, and nothing else? How many times did he say on the stand, I don't remember, I don't remember, I don't remember? He repeated it over and over and over again because he doesn't want to answer questions about what he did because he knows dang well it wasn't justified. He's lying. He's lying. One of the many things I'm going to be grateful about when this is done is that I never have to hear again that the actions he took that day was the fault of these boys. That's ridiculous. It's despicable. There has never been any explanation from the defense as to why Nick Mew ran up on these boys, why he grabbed their tubes, why he was groping around where their legs were. They don't even respond to it. They didn't bring it up. There is no explanation. That behavior is inexplicable. He's a bizarre person. He made bizarre choices that day. It is not their fault. It is not their fault. I'll say it 100 times. It's not their fault. These boys have beat themselves up every day since this happened. You saw the raw emotion on the stand. Their best friend was murdered by this guy. And to say that it's their fault is despicable. Nobody's responsible for Nick Mew's choices but himself. He chose violence at every turn. There's been some question about whether he's fragile. Part of him is fragile. His ego is fragile. As his attorney had said early last week when he's questioning these boys, you were trying to humiliate him. You were trying to insult him. You were taunting him. He was humiliated. He was insulted. He didn't like these boys treating him like that. He certainly didn't like Madison Cohen getting in his face, so to speak. And eventually, he did just snap. He pulled his knife out, getting ready for violence, pulls it out, holds it down where nobody can see it, holds it at his side, and then hits her. That started the violence. He prepared for the violence before he started it. He felt humiliated, and he wasn't going to let it go. I asked him, did you ever take a step back at any time when she was yelling at you? No. With no explanation. We're dealing with what we call false narratives in this case. Things that the defense repeats over and over and over again, hoping that you think it's fact, okay? One of these is this 13-to-1 narrative, okay? We've heard it 100 times in this trial. This is not a 13-to-1 situation. We've got the 6 teenage boys standing on the side by their tubes. He's confronted by the 2 girls. Everybody else is in the background. He hits Madison Cohen when he's only got 2 girls standing in front of him. After the fight, it's one-on-one to start. It's Dante hitting him, and then arguably 2-on-1 when AJ comes up and pushes him in the back. Tony breaks it up. The fight's done. He gets off. And AJ, of course, is already tore open, so he's laying in the river. But that's the end of the fight. Mr. Mew continued violence. He chose more violence after that part of the fight was done. Tony, who did exactly what his dad told him to do, came up to try to break it up. You can hear him telling Dante, his brother, get away, get back. Mr. Mew turns around and stabs him, and Tony blocks it and stabs him again. He chose violence at every turn. There's another false narrative. They circled him. They surrounded him. Baloney. You've seen the video how many times there's open water everywhere. That he was attacked from all directions. False narrative. He said that Owen Peliquin testified that they stuck around because they wanted to see how it played out. That's true, but what he didn't mention is that Owen also said he wanted to make sure he didn't do anything to this woman. And you know what? Those instincts were exactly right. Those instincts were right. He keeps talking about how these boys wanted to make a video. Well, they were making a video. But what does that matter? They didn't start the violence. None of those boys laid a hand on him, despite the fact that he touched both Joanne Cockfield and Landon Wire when he ran up on them in their tubes. Nobody laid a hand on him until after he had already stabbed a number of people. Isaac Schumann tried to stop him. He got killed for his efforts. He seems to be arguing, the defense seems to be arguing that Isaac somehow deserved it. I don't understand that argument. He's trying to protect people. He calls Maddie Cohen the queen of the river, and he calls her a bully, calls her a number of other unkind things. Her testimony was, and it's clear from the video, she was trying to protect these boys. She saw that he was over there doing something, but it was freaking them out. She tried to protect them. You know, maybe if we had more people on the river trying to protect people, the world would be a better place. They've made, over and over, they've argued that Maddie was never punched because she has no marks on her face. Nick Mew, who, as Mr. Trofsky said, was lifted off of his feet by the punch from Dante and punched in the jaw and fell in the river, gets up and there's no marks on his face. We have pictures from him. We have the video. We have his interview with Lieutenant Hart later. We have the pictures that the jail nurse took 5 hours after. There's no bruising. There's no puffiness. There's no swelling. The fact that they're arguing that Maddie had no mark doesn't matter because he didn't either. It happens. They're trying to say that he was terrified. His face tells a different story. He has expressions of anger. He has expressions of, I guess, humor. He's smiling. He's smirking. Well, after he has his knife out, he clearly feels comfortable. There's no look of terror in his face at any time. KJ Martin was not armed. He pushed Mr. Mew in the back. We know that. He didn't kick him. He didn't punch him. He didn't hold his head underwater. He pushed him in the back. And for that, he got a incision on his body from his belt line all the way up. You saw the pictures. It's horrible. He used no weapon against Mr. Mew. They made a big deal about Lieutenant Hart telling Mr. Mew in the interview that she would have been scared too. Well, she made that response after he'd been feeding her a load of BS about all this stuff that supposedly happened, about having 2 kids pulling knives on him and pulling his pants down and all the baloney that he fed her. Based on that, she said, yeah, I would have been scared too. They're arguing that he had no intent to kill Isaac. Isaac weighed 134 pounds at the time. He's 250. He rams his knife up, not down, up, severing 2 of Isaac's ribs right into his heart. All right? If he didn't intend to kill him, why not stab him in the belly? Right into his heart. We've heard no explanation whatsoever as to why he stabbed Riley Madison. We know from the video she's standing off in the background after Tony's trying to break it up. He just walked over and stabbed her. She wasn't attacking him. They don't explain that because there is no explanation. None. He wasn't in fear for his life from Riley Madison. She said she was 110 pounds now, might have been 115 back then. There's no fear for his life. He just was mad because she touched him. They've talked a little bit about extraneous factors. It's not just medical attention that can be an extraneous factor. As we know, multiple people on the river stopped to help these folks, putting compressions on. One witness said they used a sandwich bag to try to make a chest compression. There was a lot of interventions for these folks. We know with Riley Madison specifically that Larry and Davis and his brother, we saw it on the video, got her to shore on a tube. People went out of their way to help these folks. These are extraneous factors. But another extraneous factor is he just got unlucky. You know, if he, as Mr. Anderson had said, we've got arteries, we've got organs. Dr. Meyer said, you know, whenever you have an abdomen wound, you have to check all those things. It's kind of a miracle that more people didn't get killed. It's not by anything he did. He just got lucky. Missed major organs and arteries. The bottom line is he had 4 hours from the time that he was arrested to the time that he concocted this ridiculous story about the boys pulling knives on him and pulling his pants down and all this other bizarre baloney. He used his intellect, because we know he's smart, to craft this story. And he was very deliberate and detailed because he wanted to come up with a story that he thought would be sufficient to convince people that he acted in self-defense. We know he lied about all of it. So now today, he's saying, well, sure, I lied about everything I said when I talked to Lieutenant Hart about what happened, but now I'm telling the truth. So now believe me. No. You have my full confidence. I know you're going to return just verdict of guilty and deliver justice to Isaac Schumann and everybody else who got hurt by this man. Thank you.
He wads up his papers at the end. Interesting finish. We're going to close out the poll here.
Now, members of the jury, the duties of counsel in the court have been performed. The case has been argued by counsel. The court has instructed you regarding the rules of law that should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the jurors, selected for this important duty. You will not be swayed by sympathy, prejudice, or passion. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duty steadfastly in mind and, as upright citizens, to render a just and true verdict. You are to decide only whether Mr. Mew is guilty or not guilty of the offenses charged. Any consequences of your verdict are matters for the court alone to decide, and they must not affect your deliberations. Multiple forms of verdict will be submitted to you concerning the charges against the defendant, Nikolai Mew. For count 1, 5 forms of verdict will be submitted. They read, as to count 1 of the information, Isaac Schumann, the jury finds Nikolai Mew guilty of first-degree intentional homicide as charged. Another form, as to count 1 of the information, Isaac Schumann, the jury finds Nikolai Mew guilty of second-degree intentional homicide as submitted. Another form, as to count 1 of the information, Isaac Schumann, the jury finds Nikolai Mew guilty of first-degree reckless homicide as submitted. Another form, as to count 1 of the information, Isaac Schumann, the jury finds Nikolai Mew guilty of second-degree reckless homicide as submitted. Lastly, as to count 1 of the information, Isaac Schumann, the jury finds Nikolai Mew not guilty. Return only 1 for your verdict. If you return a guilty verdict, you must also answer this question. Did Mr. Mew commit the crime while using a dangerous weapon? As to count 2, 5 forms of verdict will be submitted. They read, as to count 1 of the information, Alexander Martin, the jury finds Nikolai Mew guilty of attempted first-degree intentional homicide as charged. Another form, as to count 2 of the information, Alexander Martin, the jury finds Nikolai Mew guilty of attempted second-degree intentional homicide as submitted. Another form, as to count 2 of the information, Alexander Martin, the jury finds Nikolai Mew guilty of first-degree recklessly endangering safety as submitted. Another form, as to count 2 of the information, Alexander Martin, the jury finds Nikolai Mew guilty of second-degree recklessly endangering safety as submitted. Finally, as to count 2 of the information, Alexander Martin, the jury finds Nikolai Mew not guilty. Again, return only 1 for your verdict. If you return a guilty verdict, you must also answer the dangerous weapon question.
They can ask questions during deliberation, not during
As
court.
to counts 3, Dante Carlson, count 4, Anthony Carlson, and count 5, Riley Madison, the court will give you 5 verdict forms for each count that are worded similar to the ones given to you for count 2. As to count 6, Madison Cohen, 2 forms of verdict will be submitted. One reading, as to count 6 of the information, Madison Cohen, the jury finds Nikolai Mew guilty of battery as charged. Next, as to count 6 of the information, Madison Cohen, the jury finds Nikolai Mew not guilty. Again, if you return the guilty verdict, you must answer the dangerous weapon question. It is for you to determine whether Mr. Mew is guilty or not guilty of each of the 6 counts submitted to you. You must make a finding as to each count of the information. Each count charges a separate crime, and you must consider each one separately. Your verdict for the crime charged in one count must not affect your verdict on any other count. This is a criminal, not a civil case. Therefore, before the jury may return a verdict which may legally be received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror. If you need to communicate with the court while you are deliberating, send a note through the bailiff signed by the presiding juror. To have a complete record of this trial, it is important that you communicate with the court only by a written note. If you have questions, the court will talk with the attorneys before answering, so it may take some time. You should continue your deliberations while you wait for an answer. The court will answer any questions in writing or orally here in open court. When you have agreed upon your verdict, have it signed and dated by the person you have selected to preside. After you have reached a verdict, the presiding juror will notify the bailiff that a verdict has been reached. Everyone will return to the courtroom. The verdict will be read into the record in open court. The court may ask each of you if you agree with the verdict. At this time, please administer the oath to the bailiff.
You swear that you will, to your utmost ability, keep all jurors on this trial together in some private and convenient place, subject to the direction of the court, until they have agreed upon their verdict and that they are discharged by the court, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon, so help you God.
The bailiff has extra copies of the jury instructions. I imagine you'll probably want to consult with them during the course of your deliberations. I believe he has 4 or 5 sets. If you need more, let him know, and I will print more for you. He also has the verdict forms in each of the manila envelopes, 1 envelope per count. If you reach a verdict, please put that verdict signed by the foreperson back into the envelope. The other forms that you don't use can be discarded, but there only should be 1 verdict form returned back in each envelope. Now, members of the jury, as I mentioned to you at the beginning of the trial, only 12 jurors can deliberate. 2 alternates were seated in the event that we lost jurors due to health, emergency, or some form of misconduct. The alternates have been determined by lot by the clerk of court. The alternate jurors are not released from jury duty. Alternate jurors may be called upon to deliberate if we happen to lose one of the 12 jurors during the course of deliberations. So basically, the alternates are needed to be at the ready and stand by in the event that they are needed. The alternate jurors will be free to leave the building, but you may not talk about this case with anyone. You may not research or investigate the case on your own. You may not read social media posts. You may not read news reports about this case. If we need an alternate juror to participate in deliberations, the clerk of court will contact you. So we'll need a phone number before you leave. You will be expected to return relatively quickly. So please stay close to home or close to your place of work if it's nearby. We will keep your personal notes safe in a secure private location in the event that you're called upon to deliberate. At this time, I'll ask for the envelope.
Bring the envelope.
The 2 alternate jurors are Darren.
Oh, good catch. Darren. Oh, my goodness. Darren, that was close.
You may. If you'd like to have a private place where you can eat it here in the courthouse, we'll provide you with that facility. But the alternate jurors may not eat with the other 12 because the other 12 may begin their deliberations once they
because they're lesser people now.
Back in the deliberation room. Please take the jury out.
All rise for the jury.
We have started our counter. I'm keeping the cursive counter up there. Deliberations have technically begun because the jury is allowed to deliberate as soon as they're all together, and they're all together. So I realize it takes a minute or so to get to the jury room, but that's where it is. 30 seconds in, still no verdict so far.
Please be seated.
Bit of a surprise. No, just kidding. We're on verdict watch.
Mr. Anderson, do you have any objection to the manner in which I read the jury instructions?
No.
Mr. Trofasi, do you? No, sir. All right. The alternate juror forms, or the alternate, I don't know what you call this. The jurors selected for 12 the 12 jurors selected for deliberation are listed on the form if either of you need to see it. The clerk has it. You may look at it.
May glance at it
before we
briefly.
adjourn, attorneys, please stay close by in case there are questions. I do want to compliment both of you, actually all of you,
Polls
on
up
your
right now,
conduct and
0-0.
demeanor during the course of this trial. It is difficult subject matter. It is difficult law to get your mind around. These were tragic events, traumatic events, and I thought you carried yourselves with dignity during these proceedings. And I think your clients, the victims, and the community should be proud of the way that you have administered justice today. You both have given this jury a lot to think about. We stand in recess.
All right. With that, we are going to be on verdict watch officially. I'll adjust the clock so it shows. We're 2 minutes in. They've cut the audio. I have The closing from the state, the rebuttal from the state, I struggled with it. First of all, I thought it was a good effort. I think he did better than the original closing from the state. But he led with where he came in with that powerful statement. He said, one thing as soon as this trial's over, I'll never have to hear again that this was the boy's fault. That it was that they were the ones that brought this on themselves. I don't know on that. I really do not know. Where I stand on this is that sadly, Isaac Schuen's parents, their last memory of their son is going to be a video of him yelling predator, rapist, or whatever, or being part of this group that this is going on. I don't know Isaac's role in that specifically, but they, a parent likes to have, the last moments of their child. And this was not what I would say would be a proud moment for everyone to be involved in. I can't say that they are to blame. The jury might decide that. But if the jury comes back and says this is self-defense, I think that would be the conclusion. Let me just let this be a lesson to kids and parents as well, to teach your kids. As a kid, I wouldn't want my parents to see my last minutes like this. All right? Can't we just be better people? Can't we just be better people? All right. Lessons to adults too. Yeah, we've all. I tell you, the kids learn it from the adults, right? So if my kid's behaving bad, he probably learned it from me. I have as much responsibility as my kids, because I have to set the example personally. I can't expect my kids to behave better than I would, and I also believe I have a responsibility to know what my kids are doing. I don't know on this one where the parents were on that. But it seems that there were some mistakes made, and I think truthfully that a lot of people have regrets about how this went down. And as I've said before, no heroes. The counter's gone. Let me bring the counter back up. Hang on, I'll switch this to 4. There we go. Counter's back. Have to adjust it a little bit so that we can see everything. We are going to we're going to take a lunch break because. Historically, when I take a lunch break, verdict comes back. I don't think it'll happen this time. But let's see. I'm going to move this over. I think I'm going to leave the counter up. Well, I can't. Let me think. Hang on. Let's take this call first. Angela, I can hear you on my phone, but I can't hear you in person. Hang on just one second.
Voicemail, press 2.
Hey, Angela, are you there?
Yeah, I'm here. Hi, how are you?
I'm doing well. How about yourself?
I'm doing well. Well, this is the second time I'm calling in today.
It's late. It's late in the day.
Well, yeah. Actually, I just want to say something. I have a huge problem with this case. Okay. I think that, the defense opened one very tricky door. Put yourself in his shoes. Right.
They were very careful not to say those exact words, but that we heard that, yeah.
Yeah, and that's one very tricky door in this case because here's what I have a problem. He walked away and he went downstream in the same direction that the boys will float downstream,
Right.
So he would say, oh yeah, they followed me, but they kind of had to follow him because they are going downstream. It's it's impossible to not follow him. And he could have just go around, not go directly in their direction. That's that's one of the problems. And second problem is that he had 2 times to just walk away, to not engage at all in this whole thing, you know?
He did have times to walk away. And that's something the jury can consider, but he doesn't have to walk away. For self-defense, he doesn't have to walk away. That was not a requirement. So if it was self-defense, it doesn't matter if he had a way to retreat.
But also, what he said, and that's another bad thing he did, and you did highlight on your when I wrote it, that Wisconsin does not have state your ground law. And he said, I stood my ground, which is wrong. That's not a law in Wisconsin.
Oh, he doesn't.
You know?
When they say stand your ground law, the law means we will defend you. If you stand your ground, it's okay. You don't have to retreat. But they also don't have a duty to retreat law, which means he has to go backwards. So it basically, the law doesn't address it. And at the beginning, like the defense said, at the very beginning of the law says there's no requirement to retreat. But if on these lesser charges, you can consider that he didn't retreat as part of your considerations. But on the main charge, if they're going to go self-defense or not, that's not part of it. So and every state's a little different that way. And Wisconsin's a little weird. I'll say it, Wisconsin. I'm sorry, you're a little weird. I've got your laws there,
yeah. And here comes the logic / open the door the defense should not have opened, if you ask me. And that is, what would you do if you were in his shoes? What would you do? What would I do if I was in his shoes? I would walk away and not even engage with them. I would just ignore them. But also, if I did happen to do what he did, which will never happen, but if I were to do that, I would go downstream, leave whatever, and then wait for the police, turn over the knife, do the right thing, not do what he did. And you just need a little reasonable thinking to just say, okay, if I was him, I would do this, and he did not do that, which means he would just go home and whatever, he didn't do nothing, which he practically said he did that. He didn't say what he did to his wife and his friends.
I'd like to think that all of us, having the hindsight of knowing how this turned out, saying if we were in that situation, I would have done something different. I'd like to think all of us would say, look, none of us want somebody to be dead at the end of this. Okay.
Yeah.
None of us would have want that to happen. And we would have probably acted differently knowing what we know now. But the way the law is written, that's not how we view it. We have to view it how Mr. Mew viewed the situation. Did he feel threatened? Yeah. And when we watched that video, and this is the first time we've really watched that video in long segments without being paused, broken up a lot. Man, that happened fast, and there were people all over. Yeah, I felt like I was in the middle of a fight with things happening all around. I've been in a situation like that. It's scary. I have to say that watching him in that situation, if the only thing he had in his possession was a gun, I think he would have been justified in using that too. In that moment, I was guilty, and now I think he's going to be on the lesser charge, at least for the murder, because that's not just crossing the line. That's jumping over the line. The one I have the hardest time with is that last video. They called it the Sasquatch video. I think Mr. Mew called it. It looks like a video of Sasquatch or something. That last video that ended up being really blurry, where they had to say, this is, see the white shorts and the dark shorts, and this is Mr. Mew. As long as we accept that all those identities are right, and I think they are, I think they got them right, it sure looks like Mr. Mew walks up to somebody who's standing still and stabs. Yeah. That one, I can't, if that's what happened, I wish I could watch it again with more clarity to understand, and with audio so I could tell what was happening, what was being said. Because if there was a threat coming and he thinks he's still in the middle of a fight, that's viewed differently than if everyone's trying to leave and fleeing for their lives, and this guy's just struck with fear and can't move, and you just come up and stab him. But that one might be different. So we might have a split verdict if the jurors feel the same way.
Yeah, I actually don't think they will come as guilty to the girl that was punched. What's the name?
Madison?
You know who? Madison. Yeah, because she was like a clear threat to him, and I can see jury coming to like not guilty because of self-defense, actually. But the other charges, I think it's lesser included, the least less included. Like I don't know exactly. You know which one I mean.
Yeah.
So yeah. That's the only reason why I called. Sorry to take away from your lunch.
No, you're good. You're good. I'm still trying to fix this timer so it looks good on the screen. I'm not sure how I want to make it, but
yeah.
Angela, it's always good talking to you. Thank you very much.
Yeah.
We'll talk to you again soon.
Bye-bye.
Bye. Bye. All right. As Verdict Watch continues, we're at 12 minutes and 56 seconds. We are going to wrap up here before we hit the 6-hour mark on the live stream, because that just solves 1,000,001 problems for the channel. Let me just tell you. Please announce the results of the polls. Let me do that right now. Just 1 second. Oh, we have somebody on the phone too. Is this right?
Call from Jessica.
Jessica, how are you doing?
I'm good. How about you? I don't want to take away from your lunch.
Oh, you're adding to my lunch. Normally I would just be eating in silence, but here you are sharing with us.
Oh, well, that's sweet of you to say.
What do you think about?
Okay, real quick. There's 3 words that I really think that the prosecution probably should have said a little bit more, and that's consciousness of guilt. If you're in shock, right? And I've been around people in shock in multiple ways. People who have committed crimes, people who have been, party to a crime, people who have been victims of crime. Yeah. And shock doesn't usually allow you to elaborate these fantastical stories, because you don't know there's video, right? And I'm not suggesting that he's going to be found guilty on all of the charges. What I'm saying is that his actions after the incident, to me, don't favor him in his self-defense claim.
I 100% agree. 100%.
Because if you don't think you did anything wrong, or even if you didn't feel like, it was what happened, you have a phone, you can call 911, you walk past police officers, that you don't say, hey, these guys, they attacked me. So I think that the prosecution made a good point about that, is that, you don't, and it is convenient that he doesn't remember things that are incriminating, but yet he remembers things that are not.
Yeah.
So I think that the problem that I would have if I was a juror on this particular trial would be that he showed cunning and consciousness of guilt after the fact.
Let me ask you this. Is it possible that Mr. Mew is just a habitual liar? That in his very nature, day in and day out, he lies nonstop? Could he still have the right to self-defense?
Well, sure. But in the event that you're looking at facts and you're looking at what has been presented to the jury, they haven't presented that he was a habitual liar, right? And they
said he lied about everything he said.
Well, he lied about everything he said for the case, right?
Oh, I don't think,
because he was able to hold a job for how many years? He's able to successfully get how many degrees and speak how many languages. And he was able to hold a relationship.
The smart ones are always the ones you have to watch for, though, right?
No, of course. But the smart ones usually don't get caught.
Yeah.
Right? Usually they're a little bit, like sociopaths or other people are usually pretty good at masking, or I'm not saying that he is a sociopath. I'm just saying just in general. But I agree with you. I mean, that doesn't mean that he wouldn't be, just like a prostitute could still get SAs.
Right.
That doesn't mean that they're any less deserving of a defense,
right,
or protection. I'm not saying that at all. But I think in this case, he is saying, "Well, believe me now."
Yeah.
I just find it. That's the hardest thing for me to get over in this particular case.
I have to wonder if there's any cultural reasoning behind his behavior. And I don't know. I don't know coming over from the Balkans. I don't know what that would be like, how that would play in. But it does, I will say, it was bizarre behavior that it sure didn't help him. I mean, if he had just stopped, I mean, I'm not even saying you have to render aid, but if he had just stopped and just said, they attacked me and I stabbed them, and just said what happened from that moment on, call 911, whatever, just the bare minimum. Even if he had just laid down in shock and not said anything, it would be a very different case for the jury, I think, than what we have right now because of his actions. And we're sitting here looking at interviews with police and weird stories with events that clearly didn't happen, and deceptive behavior.
Right.
But I don't see in the before videos, I don't see, and we don't see a lot of it, but I don't see him setting up the situation as this is what he was going for. I don't see intent anywhere. If anything, it was almost reactionary. And so I just can't go with a maximum charge even on that.
Right. No, but the forming of intent doesn't have to be in a less than a millisecond. An intent is not, they don't quantify an intent by a length of time.
Right. But
I don't think that he had premeditation. I don't think that he didn't think, I'm going to go over to these kids and I'm going to mess with them. I don't think that he had the intent to go over and start this at all. I don't think that's true.
But it's intentional homicide, right?
Right, but the intentional homicide, when I say premeditation, is different than intent. I don't think that he premeditated in his mind, I'm going to go over and I'm going to mess with these kids. I think that the intent is formed when he chose to take his knife and stab someone in a vital part of their body.
Yeah.
And that's where I think that the prosecution is arguing. And then one last point, as far as the cultural thing, I think that might work against him somewhat too, because it could be that he doesn't appreciate women telling him what to do, or he doesn't appreciate women getting in his face, or young people yelling at him. I mean, I don't think anybody likes that. I mean, I certainly don't.
Right, but it's true that there are other cultures where respect is more demanded or expected than we seem to have nowadays in the U.S. So that's a great point.
Yeah,
great point. All of them actually.
And listen, I do thank you. I do think that the boys were obnoxious and were emboldened by, the moment and their intoxication levels. But you can yell at someone and stand there and say things that are horrible. Now, I don't recommend it because not everybody's going to show restraint as it's supposed to by the law, right? But at the same time, you have to understand that your actions have consequences. If you make people feel fear, you never know what they might do. So I'm not suggesting for a second that they're, absolved from their actions. I don't believe that they should have been, I don't believe that. However, I will say this much. It is a very quick moment in time. I mean, that whole entire video is like seconds long.
Yeah.
The only thing I would say is I noticed you watched the first day of the trial, like at 1.5 speed. The first witness, I don't remember what his name is, but he was the first witness that the state called. And they played the video like within a few minutes of his introduction, like, who are you and who's this gentleman to you and whatnot. They play the video in real time, so the entire length of it. So if it's something that you or anybody else wants to actually watch.
Did the camera show it all?
They did.
They did? We might go back and watch that.
They did.
I don't remember.
At least that's what I remember, because I was watching it from day one, which is kind of why I was out of chat for a while, because I didn't want to really get that trial because I have friends that live in Wisconsin and in Minnesota. So anyway.
We watched at high speed, so we might have to go back and watch the whole thing on normal speed.
Yeah, it's fast even at regular speed, but you can see how fast, the things happen. When they slow it down, it makes more sense. But at first, it's like, so I can understand why some of the boys were laughing. Some of the people were like didn't know that he had a knife, because it happened like really quick.
Yeah.
So anyway, that's all I wanted to say. It's going to be a difficult one. I'm not really sure where I stand, but for those reasons I mentioned, I did have a problem like I said, with his actions afterwards and his convenient memory loss.
Yeah, that
but
wasn't very
whether or not
convincing,
he
was
gets
it?
convicted, not to me. I mean, his reasoning for what he did, like trying, after the fact, saying he stumbled into their tubes. Okay, well, I can maybe get that, but you were running before that. So, I mean, what was it then, right? It sure did seem to me like you were upset when you put your snorkel in your mouth and then you ran towards them, like, okay, I want to keep these secure. And then he was mad about his goggles, and then he was mad about people yelling at him and calling him names. I mean, why not just admit that? Like, yeah, I was upset. Yeah, I was angry. But it doesn't fit their narrative, right? So
It doesn't.
Anyway, it's going to be difficult.
It is. I don't envy the
All right.
jury's job, although, one day I hope to
don't.
be on one. So we'll see
Same.
what happens.
Same, but they never let me.
No,
They never let me.
I don't think I'll be let on either. Thank you so much. You
right.
have amazing ability to speak at all to this point, and you've done a fantastic job. Please do it again. I appreciate your call.
I will.
Thank
I
you.
will.
Good talking to
Thank
you.
you so much. Bye, Pat.
Yep.
Bye.
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 Amazing, wonderful. Okay, we do have to end before the 6 hour mark. That's and my wife has reminded me that that's approaching rapidly. Hurry and stream, hurry! I've got 15 minutes. We can wrap up. We've got a new stream set up that we're going to redirect to because we are going to be on Verdict Watch. Well, the Verdict Watch is happening. We might jump around into a couple different courts. I know we have, we've got this one over here in up in Idaho, right? With Chad Daybell going on. We're watching that. But we've got lots of things happening. So we'll have some courts to watch. We'll watch the timer as well as we watch for questions and everything else. So we're gonna take a break for lunch. I suggest you guys do as well because lunch is good. At least I hope lunch is good. Mrs. R.A. Hint, hint. Do we have anything for lunch? What's the 6 hour YouTube issue? Labman, if I need to make an edit to a video, if it's over 6 hours long, I can't. And sometimes we have to edit videos if there's a part that YouTube doesn't like for some reason or another. So sometimes even if it's just a couple seconds, I can't make that edit unless we're under 6 hours. After 6 hours, they're like, look, we're not going to store this forever on our server for you to edit if you so choose, just because the file's so big. Hopefully they raise that up to like I edit out Ivan's calls, all of them. Yeah, you just delete. You guys, thank you very much for being here. If you've joined here for the first time, click the subscribe button. We'd love to have you back again, maybe for the rest of Verdict Watch or for another trial, as we tend to do this every day, all week long. Tonight, when you go home, please hug the people you love. Smile at someone, make their day just a little bit better, and please stay safe till we go live again in just, I think, 3 o'clock. That'll give us about an hour and 8 minutes. I will update the thumbnail. Steve, I'll update it. I promise that. It will change as soon as we end here and the new one goes live. Let me actually have to redirect us really quickly because I forgot to do that. I said I did it, but then I didn't. There we go. Now we're set up. Okay. Save. All right. So we'll redirect to the right thumbnail in just a little bit. I think that's all. When's Treehouse Trial? I don't know. We're going to have to do some research. I'm going to expect all you guys to pull your weight on that as well. I'm not the only person with Google here. So we'll learn a little bit together, maybe find a couple fun court cases to watch, brief trials while this all happens. You guys have a great lunch. Be good to each other. We'll see you in a little bit. Bye-bye.
When are we going to break for lunch, Judge?